Hello, everyone. Welcome to your final day of NGO this week. We are, as always, excited to see you all. I promise this is the last time you're going to hear me say this week, but please remember that you can use the chat box for questions throughout the presentations. And then also go ahead and reference the chat for information about how to access closed captioning if you need it. We have a great joint presentation for you today during this first couple of hours. So without any further ado, I will go ahead and turn it over to our presenters.
Thank you, Miranda. Hello and welcome, everyone. I'm the Deputy Director of the National Immigrant Women's Advocacy Project. And Kirsten, why don't you say hello?
Hi, everyone.
Hi. So today we're going to talk about legal options for immigrant survivors of domestic and sexual violence and how NUAP and how ASISTA can support your work. We have a lot of material for you because we want to give you just a taste or a little sampling on how we can provide technical assistance and support for you. A lot of it is here for reference for you. Our director, Leslie Orloff, will also be joining us to this as soon as she is able to, coming from another presentation. Annette kindly shared for you here the materials and the links that we're going to share during this presentation. And before we get started, I just want to say, congratulations on your award. I know that you guys will do a magnificent work and an impact to working with survivors. And so let's get started on how we can support your work working with immigrant survivors. This is a quick thank you to OVW and our grants, and our opinions are our own and not necessarily of OVW. And then just a quick introduction for me. I started at an LAV program at the Wisconsin Coalition Against Domestic Violence as an immigration attorney there, and worked with immigrant survivors doing VAWAs and U visas and T visas. And I worked together very closely with a family law attorney and advocates. And so that partnership really supported how we provide services in a holistic way to immigrant survivors.
Hi, everyone. I'm Kirsten Rambo. I'm the Executive Director of ASISTA. Very, very happy to be here co-presenting with Rocio and Leslie today, our friends for a long time. And collaborators for a long time. I will also share congratulations on your award. And I'll tell you, I have been an LAV grantee myself, going back to, I think 2003 was the first time when I was at the Georgia Coalition Against Domestic Violence. And now I'm with ASISTA. I'll tell you a little bit more about ASISTA coming up, but just very happy to be here with y'all today. And I know you're coming down the home stretch of this training, and we appreciate your engagement with us today. So let's talk a little bit about our learning objectives. This is what we have lined up for you in this session. The main thing is that by the end of the session, we really want you to know how NEWAPs and ASISTA's technical assistance, trainings, and resources can help you and strengthen your work with immigrant survivors. What's part of that is dispelling some of the myths that are out there by understanding the realities and dynamics experienced by immigrant survivors that may be particular to immigrant survivors. Along the way, we want to help you gain insight into some of the laws and legal rights that are out there to support and increase safety of immigrant survivors, identify the immigration options for survivors and other crime victims, and ways to access immigration relief and increasing access to public benefits, which we know are super important as part of economic justice. And then lastly, to identify unique issues that impact immigrant survivors' safety and the way those outcomes can look in family law, child custody, and support orders that connect to folks' immigration status.
And here's the link that Annette shared that has these links and others and the slides that we'll talk about. We're going to start off with telling you about who we are and what kind of support services we provide. And so this slide of who we provide, technical assistance, it's federal law enforcement, prosecutors, victim advocates, and attorneys, but really it's anybody that's really looking to improve their work and response to immigrant survivors. We do it through training and virtual training, and we'll work with you to tailor it to your needs and your community. If maybe all you have is an hour to do a training, then we can do that. But we've also done, 6-hour trainings and in-person trainings. And so we can come down to you and do on-site visit, but that's part of our virtual training that we have. We also have past webinars that are available on our website. We have a great resource hub in our webpage that has a tab for every area that you think that might impact immigrant survivors, and that library truly has everything that you can imagine. And if it's not there and you think that it's a tool that can support your work, do let us know, because that's our goal, is to try to, if you need it, it's probably somebody else needs it too. And so we want to be able to support you that way. And then there's also technical assistance. So you can reach out to us on a one-on-one level and let us know, case specific inquiries and how we can support you that way.
Right. Well, I want to share a little bit about ASISTA. Our mission, as you can see, is to advance the dignity, rights, and liberty of immigrant survivors of violence. And for us, that usually means gender-based violence, domestic violence, sexual assault, dating violence, stalking, and outside the purview of our OVW grant, that's something we also work on, is human trafficking. So there are a few ways that we do that. One key one is technical assistance. If we can just, well, actually, we don't need to go back for a slide. That's okay. But just to tell you for a sec what our technical assistance is, basically it's individualized assistance on a particular question or a particular case. So that might be an answer to a specific question you have about a particular case, might be us helping you brainstorm solutions or strategies for a thorny issue that you're facing. It might be that you're reaching out for resources, samples or citations. It might be us helping to review some documents that you send our way. Sometimes it can also include direct case intervention to agencies where we have relationships. So whether it's the Vermont Service Center or ICE or USCIS, those kinds of things, if we have relationships and if the case is at a particular point where it would be helpful, then intervention is also possible. So in terms of who can access our training, our technical assistance, we have a network of what we call private members, folks who pay for ASISTA membership, and those are attorneys and advocates across the country who are representing immigrant survivors of violence. For our purposes here today, the other folks who can access our TA are OVW grantees, specifically LAV grantees and STOP sub-grantees. In other words, you, and thanks to OVW through our grant, you can access our TA and trainings and other things for free through your grant. So we encourage you to do that, and that's a big part of why we're here today. We also do training, and for our OVW grantees, we do lots of training. So 6 to 8 webinars per year, typically, that are 1.5 to 2 hours each. This is just an example of a sort of recent training that we did. We'll get into some more of these topics later. Our trainings are virtual, so we provide those for you mostly over, online, through the TA to TA platform, and lots of resources that go with those as well.
Yeah, and CLEs, right, Kirsten? Yeah. So that's always very, very helpful. I know as an immigration attorney that the ASISTA was a very important in me being able to get those resources and learn more about these remedies, especially representing the immigrant survivors.
Yes, we're happy to help you get your CLEs, and we always get CLE credit through Texas and provide certificates for your attendance if you want to apply for those elsewhere as well. We also do policy work, and then we also do litigation work, and we don't do this through the OVW grant. It's just something to know. It's, you know, we support some federal litigation through amicus briefs, you know, affirmative litigation efforts, things like that. I don't want to spend too much time because it's not something that we do through OVW, but it's another aspect of our work that's a bit more macro level along with some of our policy work. So I threw this in as just a tiny little snapshot of some of our statistics from this past year, just to give you a sense. So through our TA and things, we helped over 3,000 immigrant survivors and their families that came from more than 75 countries across the world. There's a fun picture of the VAWA celebration at the White House. And Leslie, hello and welcome. I remember seeing you there.
Yes.
That was a great day. And then just the attorneys and advocates that we trained as well. And the other thing I wanted to mention before we move on is the Alliance for Immigrant Survivors, which is a national network of advocates and allies that advocate for policies to provide safety and justice for immigrant survivors of gender-based violence. We're one of the 4 co-chairs of that group, along with Esperanza United, Asian Pacific Institute for Gender-Based Violence, and Tahirih Justice Center. I bring it up because AIS has lots of practical resources that can help you. Their website is there, and you can also sign up to be on their listserv. Much of it is policy oriented, but as you'll see as we go, there are things like resources on public charge, for instance, and some of our work at ASISTA and the other orgs flows through AIS. And so there's some great stuff there if you want to check out that website.
Yep.
So,
and this is a great place because we just talked about who we are. So perfect opportunity, Leslie, to share with LAV grantees a little introduction before we go in to this poll, and maybe they can answer the poll while you do that.
Sure. Yes, so welcome. I'm Leslie Orloff. I direct the National Immigrant Women's Advocacy Project, American University Washington College of Law, and we are here to support you in a lot of different ways. We'll be going over and giving you a small taste, a small but quick taste of the various different kinds of topics that we can support you in your work with immigrant survivors. So I really do emphasize that immigrant survivors, as you may know, as with all domestic violence survivors, have a multiplicity of needs. So they need immigration help, and getting immigration help gives them more access to public benefits and gives them more confidence to seek a protection order or to do the family law work. So it's all connected. I am the presenter here who started their career as a family lawyer. I was involved in drafting VAWA T-U and the VAWA cell petition, the T visa and the U visa originally. And we too do a lot of work with federal government agencies helping make sure, as part of our TA, that immigrant survivors can actually access what they're entitled to from Department of Homeland Security, the Department of Health and Human Security, from HUD, from local agencies, state benefits agencies, and the like. So I'm happy to be here, and we look forward to talking to you today and working in the future. And in the meantime, I see we've got about 30% of you are legal services lawyers, 13% of you are family lawyers, 14% are immigration lawyers, about 16% of you work with coalitions, and I'm always really curious what the 28% is. So do you want to summarize that, Rocio?
Yeah, we're seeing a lot of administrative staff within programs and coalitions, legal directors, and so grant administrators. So a lot of other important players that are here to support immigrant survivors. You know, and with that, we want to share with you what is, the growing population, and I know we are all aware of the growing population of immigrants in this country. Leslie will share that data, but I did want to share with you that we have each state demographic in your state on our website, and you can look up by your state what demographics are around you. And that's important when you're planning for language access or seeing what kind of survivors you might encounter.
Great. So, so these are a sample, a couple of page sample of what we have on the demographics. So what's really important here is we've got the total foreign-born population. About immigrants make up about 13.7% of the country's foreign-born population. What's really important is that, and this data comes from the Migration Policy Institute, and their demographers have run for us every year they update it, the state-by-state numbers on lawful permanent residents. And the reason that's important is you'll see that, I'm just looking at my math, just under 75% of the foreign-born population in the United States who are actually either naturalized citizens or lawful permanent residents. Now, you will see victims who are naturalized citizens and lawful permanent residents in your practice. And from the family law and public benefits perspective, you'll have a lot of work that you can do with them unrelated to their immigration status. The population of immigrants that benefit from the immigration protections available through VAWAs and Ts and Us and that we're going to be talking about today are these temporary visa holders and undocumented persons, which make up about 27% nationally. The other number that's really important for those of us that are family lawyers on this is that 25.8% of children under the age of 18 in the United States have one or more immigrant parents. And there's a lot of us that that's true of. And it means that, a lot of our family court cases are going to involve, even if it's citizen children, they're going to involve immigrants. And so the next slide gives you a picture of we have these for each state, what it looks like in terms of countries of origin and in terms of the proportion in your state and nationally of limited English, of foreign-born people who are limited English proficient. For every state, we also have slides where you can see the languages spoken at home are not, the number of people who speak languages other than English at home is a much bigger number, and the proportion of each of those populations that speak those languages, the portion that's LEP is going to vary dramatically. So for example, we might also always presume that the limited English proficient population, the biggest group is Spanish speaking, but that's actually not true. I was just in Florida, for example, where the Chinese speaking population had a 50-some-odd% LEP rate, where the Latino population had a third. So it varies by state, and we have all those demographics data for you.
So the Department of Justice, and everyone that gets any type of federal funding, like us as grantees, defines it as legal language assistance that's accurate, it's timely, effective, at no cost. And then, LEP means limited English proficient to that individual, to where our services that we provide to them cannot be delayed or inferior as compared to the way it is for English proficient per individual. So that is how they're defining meaningful access. And there's an executive order where the goal is that we provide meaningful access to limited English proficient people. There's instructions and guidance through Title VI and through the LAV v. Nichols case. And the goal is and encourage us to develop language access plans.
And what's really important, again, for the family lawyers and legal services lawyers here, next slide, please, is that the Department of Justice has issued guidance not only for law enforcement and prosecutors, which we also train on and talk about, but for courts. And so the courts are supposed to be providing interpreters in all proceedings. So it's not just criminal and protection orders. They're supposed to be providing them in family court. And it's not limited to courtrooms, and it's all types of proceedings. It's including batterers treatment and therapy and drug counseling. So that's part of our advocacy as lawyers and as grantees, is to do what we can to make sure that we are getting that we're getting interpreters for our clients in state court. And it varies what's available locally, and we do lots of technical assistance to help you prep to make sure that you get a mom interpreter in that family court case you have when you need it. Not just Spanish, not just English, but the other languages that your clients may speak.
So as we talk about the special laws and protections that are available for immigrant survivors, let's do really quickly why they are needed. So here is a quick poll. So abusers of immigrant spouses are more likely to be another immigrant or lawful permanent resident than a U.S. citizen. True or false? And we can type that in the, oh, no, we have that poll. Thank you, Annette.
Yeah, and Annette, we're going to be driving you crazy with a few of these in rapid succession. So,
and so a lot of you are answering true, going a little more to false. It looks like a lot more false than that, but
and they are correct. Next slide, please. And that, well, these are in my way, so I can't see, right? Okay, so basically what we find is where there's power and control over immigration status, there are higher abuse rates among immigrants, but they're highest when the abuser is a U.S. citizen spouse or former spouse, where the abuse rate reaches almost 60%. Next slide, please. And that, and yeah, so here's the data, the 60%, and that researchers found that generally there's been research among Latinos and South Asian women and, people from the Middle East, and you're seeing the same types of patterns. This pattern is the same without regard to population.
Next poll. In over 70% of abusive marriages, U.S. citizen husbands refuse to file or withdraw immigration papers they filed to sponsor their abused immigrant spouse for lawful permanent residence. True or false? And here we're seeing a lot of you all thinking and participating. Thank you. We're seeing mostly trues there, Leslie.
Yep. Next slide, please. And that it is true in over 70% of the time when an abusive spouse could file papers for their victim immigrant spouse, 70% of the time they never file. And when they do file, there's a mean delay of almost 4 years. And this is reported by 60% of survivors. So it's really, really high rates of this overlap between with immigration-related power and control and abuse. Next slide, please.
And now let's look at how that impacts. So foreign-born girls are twice as likely, in another poll, twice as likely as U.S.-born girls to have experienced sexual assault by the time they are in high school.
And again, we're seeing, you guys are quick, very good. We got about half of you in already. And what we're seeing is that the answer is true. There was a study done in Boston, in the Boston school systems, looking at sexual assault generally on girls by the time they reached high school, and foreign-born girls were twice as likely. This has to do with their vulnerability. It has to do with power and control over immigration status. But we see that, and we see that immigration-related abuse in all relationships, not just of younger girls, is 10 times higher when there's physical and or sexual assault happening in the relationship, as opposed to only battering or only extreme cruelty or different kinds of psychological abuse. So that evidence of domestic violence, that power and control over the immigration status, is something you can provide as evidence of domestic violence and power and control and coercive control in your family court cases, and in your immigration cases as corroboration of abuse. Or it also means if you're looking at a relationship where the abuse is maybe at a lower physical level, it could be predicting that the abuse rate is rising.
And to
or
me,
is
that
likely
means,
to rise.
yeah, to me, when I'm screening, when somebody, a survivor, shares with me that there's immigration related abuse, like not filing for papers or threatening of deportation, that could be an indicator that you probably should be screening for other forms of abuse like domestic violence and sexual assault. And so because of that, Congress came up with immigration options for immigrant survivors. And Leslie, since you were there when they developed them and you were key in that,
Right.
why don't you share with us why?
I mean, Congress was trying to do a number of things when a number of things were discussed, and I was in the room during the negotiations. They were trying to improve access to justice. So they were trying to improve access to police, to prosecutors, the relationship between communities and prosecutors. They were trying to improve access to victim assistance. They were trying to improve access to the courts. And they were trying to improve the ability of the justice system to hold offenders accountable and to offer protection and services to survivors. All of that, and what social science research has began to prove then and is proven since then, is that by doing this, we're improving victim safety, community safety, and law enforcement officer safety. So there's lots of different reasons, and you LAV grantees are what make these laws work in the lives of the victims that you work with.
Survivors that apply, they get protection from deportation. They get VAWA confidentiality, and we're going to tell you what that is. They can include their family members in the applications, and that includes VAWA applicants, U visa and T visa members. They have access to legal immigration status, and very importantly, they get financially independent from their abuser or perpetrator of that crime, so that authorization to work is key to being safe. Many times the issuance of an ID, and that opens so many doors, and then access to federal benefits. So having that immigration relief opens the door to be able to access public benefits and support services that are key to staying safe. Here we're sharing with you this infographic, and it's in the link of the resources and materials. This is a really cool infographic coming from the Department of Homeland Security, and I love it because you can just print it off, but also it's great to access it online, and you can click on the different pieces of it. It's a shield, right? Because it's a protection. And you click, it tells you where the forms are. It also tells you what are the eligibility criteria and what you get and what benefit if you're approved. Great resource to share with your partners. Today, we're going to talk about VAWA, U visa for crime victims. Continued presence is for prosecutors. And for victims of trafficking, we'll talk a little bit about special immigrant juvenile status. Asylum is for victims fleeing persecution, either already here or entering. And we'll also talk to you a little about T visa for victims that are severe form of trafficking. Here is a list, and this is all the crimes and all the acts and all the criminal activity that someone can be eligible for immigration relief with those immigration protections. So largely here with our funding from OVW, we see domestic violence and intimate partner violence, sexual assault, rape, stalking, and it also includes the crimes and acts that you can see through special immigrant juvenile status, so parent perpetuated child abuse, neglect, or child abandonment. But this is a good checklist. And if a survivor you're working with is a victim of one of these acts or crimes, it's very likely that they might be eligible for immigration relief. And so do take a look at that. The first form of immigration relief, and it's often the one that's the quickest to lawful permanent residency and also gives you the most access to public benefits is the vow of self-petitioning. And so here, a person, if they are subjected to battery or extreme cruelty so there has to be that qualifying relationship with a U.S. citizen or permanent resident. A lot of times it's their spouse, parent, or step parent, and it could also be their adult child or son over the age of 21 with whom they've resided. So there doesn't have to be a time period that they've resided together, because safety here is a key concern. They have to have good moral character. If it's based off a marriage, then that marriage had to have been formed in good faith. That's how someone can be eligible for the vow of self-petitioning. And battery and extreme cruelty, we're going to tell you what that means, but it doesn't, I want you just to remember, it doesn't necessarily mean physical violence. There's a remedy very similar to the vow of self-petition for those survivors that are in removal or deportation, and that's the cancellation of removal. And then the battered spouse waiver is for those whose spouse already started or parent started to petition for them in their conditional residence.
Next slide, please.
And so battered spouse waiver is, for 2 years. If somebody is already a lawful permanent residency and they have it for 2 years, the battered spouse waiver allows them to remove the conditions and have the full lawful permanent residency without having the assistance of the abuser. There they would show proof of battery or extreme cruelty and good faith marriage. Here are examples of forms of extreme cruelty. And so, like I said, it's battery or extreme cruelty. It doesn't have to be physical violence. And it includes different forms. One helpful tool, and I shared it with you in the website, is the power and control wheel. And it just helps you when you're screening to make sure you're not missing one of these tactics of abuse, but it includes emotional abuse, economic abuse, sexual abuse, isolation, harming pets, other types of acts that can constitute extreme cruelty.
And we put together this chart. This is actually a tool that we developed with the stalking with Spark, and that are the experts on stalking. And this looks at, it gives you an easy checklist to kind of see what battering is, see the kinds of coercive control that can serve as a basis for extreme cruelty, and the other kinds of actions or dynamics that can be happening in this relationship that constitute extreme cruelty. So other way to think about it, again, for the family lawyers in the room, is that if you can get a protection order in your state, you absolutely have battering or extreme cruelty. This is a broader definition of domestic violence than what you need to get a protection order in your state. It includes forms of relief where the abuse hasn't risen to the level needed for a protection order under state law.
And so how a survivor will show that they are been extremely battered or extreme cruelty, the burden of proof, or what you need to show immigration, is any credible evidence, because they understand that not all survivors are going to have access to the best form of evidence. And so they're very flexible. They have training in victim dynamics, and these are confidential applications. All that we'll talk about, they're protected by vow of confidentiality, but someone can show that they're eligible with affidavits, their declaration, protection orders, court records, email notes, photos. Here's a list of examples of how one can prove that they're eligible, and how someone can safety plan in advance, knowing that the documents that they may need, even if they're not ready to apply at that time.
And we have some of the tools that we have available on our website and to you include all kinds of evidence checklists. So you can kind of go through and think about, how can I collect this? And again, family lawyers can use discovery and protection order cases to get your hands on some of the evidence and information that the perpetrator made.
Right. And so because there may be survivors that are not married to their abuser, and there might be some perpetrators that don't have a lawful permanent resident status or are U.S. citizen. Another remedy that many survivors can be eligible for is the U visa, and I'll let Kirsten share about that.
Thanks, Rocio. Yeah, let's talk for a minute about the U visa. This is a really important tool, and it is key, as Rocio said. This is distinct from the VAWA self-petition, in that your relationship as a victim of this qualifying criminal activity, your relationship to whoever committed the crime does not matter for the purpose of a U visa. So we think about those VAWA self-petitions, if it's someone that you've been married to or are married to, for instance, with a U visa, it could be a stranger. That's okay. The requirements for a U visa, you need to have been the victim of a qualifying criminal activity. What is that activity? We're going to look at that in a moment. It's a broad list. In addition, and this is also key for a U visa, the victim has to have been helpful, or is being helpful, or is likely to be helpful in the detection, the investigation, the prosecution of this crime, or the conviction or sentencing. Who determines that, and how we how that gets proved is through a law enforcement certification. So for the purpose of a U visa, someone from law enforcement, we'll get into more details momentarily, has to certify that that victim has been helpful, is being, or is likely to be helpful in one or more of those aspects of investigation, prosecution, etc. It's a really key component for the U visa. In addition, the victim has to have suffered substantial physical or mental abuse as a result of that qualifying criminal activity. That person has to possess information about the crime. The crime needs to have occurred in the US or violated US law. Another key thing to know about U visas is that, unfortunately, there is a cap on how many our government will give out each year, and that cap is 10,000. Unfortunately, as we know, there's no cap on victimization. So we hit that cap pretty early every year. That is why it takes a long time to process these cases. It takes a long time to even get on the wait list. And you can see here, it's currently about 61 months just to get on that wait list. So we're talking 5 years. USCIS is currently reviewing cases filed 5 years ago. If you were to file today, you would expect 14 years or more, probably, for that final U visa adjudication. It is a long slog, so that's something to keep in mind. Again, there are things that can be helpful along the way. We're going to talk about benefits and things, but important to know that with that U visa, it is a long process. So in terms of qualifying criminal activity, again, there's a big list here. Many of those things are things that are covered by your LAV grant. You can see DV, sexual assault, rape, etc., and attempt, conspiracy, or solicitation to commit any of these crimes or any similar activity can also count for that qualifying criminal activity.
Yeah. And if you want to note, it says activity, it doesn't say crime. Different states will have different names for these types of activities. And so it's not determinant on what was prosecuted or what was charged, but really what is it the activity that occurred. So in domestic violence, you might have the domestic violence, witness tampering, and stalking. And those sometimes are the 3 crimes that kind of occur at the same time. And so and it's any attempt or conspiracy or solicitation to commit any similar crime.
Thank you. We talked about needing that certification, and we typically think of law enforcement, could be local, state, federal, could be university law enforcement. You may live in a jurisdiction where, for whatever reason, your local law enforcement is not as helpful with signing these certifications as you might like. As advocates, there are things you can do, and we encourage you to work with your local law enforcement to improve that relationship and help educate them about the benefits to them and the community, and to survivors about signing those certifications. But in the meantime, keep in mind, there are also prosecutors, state and federal prosecutors, judge and other judicial officers, tribal judges, adult and child protective services, EEOC, labor, and other authorities with the responsibility for investigation or prosecution of criminal activity. And it's important to keep in mind, this is a nice, decent sized list, and this certification is required for that U visa to go forward. So if your local law enforcement are not willing or able to sign that certification, think think big, think about this list, think about what other options you have to get that certification. And now we're going to move on to the T visa. This is for victims of severe forms of trafficking in person. So this includes sex trafficking and labor trafficking, where the person is subject to force, fraud, or coercion, or if the victim or survivor is under 18 years old, you don't need to show that force, fraud, or coercion. The victim needs to be physically present in the US on account of the trafficking. And the victim for a T visa must comply with reasonable requests for helpfulness in the investigation or prosecution of that trafficking, unless they're under 18, or unless the trauma from that, whether physical or psychological, could impede their helpfulness. It's important to note that certification we talked about that is required for the U visa is not required in that same way for a T visa. So have to be helpful, but it's a little looser on what that looks like. Also for T visa, have to show that removal from the US would cause extreme hardship. And you can see here that work authorization and many of those public benefits, both federal and state, can kick in between 3 and 18 months. So much, much quicker than we have with the U visa. And the last thing we're going to talk about just quickly is special immigrant juvenile status. And this is something that allows immigrant children in the state juvenile system who can't reunify with their parents due to abuse, abandonment, or neglect to obtain lawful permanent resident status. So eligibility for CIGIS, you need to be under 21 years of age on the date of filing that petition with Homeland Security. You need to be unmarried throughout the process of the adjudication of that petition. You need to stay present in the US through the adjudication of that petition. This one requires a juvenile court order, a family court order, with required findings and conclusions of law. The dependency or custody of child is defined by state law. It has to be in the best interest of the child not to return to the home country, and why that parental reunification is not viable with at least one parent, whether it's abuse, abandonment, neglect, or something similar under state law. The timeline to approval and work authorization for this is shorter at 6 months. So that's a quick run through of U's and T's and CIGIS. We're packing a lot into this presentation, and happy to answer questions as well. But I'm going to quickly tell you as we wrap up this section about some resources from ASISTA that will help you with these matters. Technical assistance we talked about, the interventions we talked about. Later in this presentation, I'm going to tell you how you can access those things from us. We want you to access them. We're here for you to access them. So we'll talk about that later. We have publications on these things, practice advisories and some shorter practice pointers, webinars and other trainings. That's a live link, and I know you'll get this presentation to our YouTube channel. Our listserv is called VAWA Experts. You all have access to that as LAV grantees, where you can brainstorm and sort of reach out to colleagues about cases and challenges that you have with this. And then we have the option of on-site training in TA, where we may be able to come to you, but we'll talk about that a little later. And I'll let our NEWOP friends tell you how they can help you.
You're on mute.
It works so much better when I'm not on mute. But very similarly to ASISTA, we also have technical assistance and training. And a lot of the people that are in our audience, it's more mixed. I wouldn't say we're just immigration attorneys. We try to keep it more basic. A lot of advocates that are working with immigrant survivors and non-immigration attorneys, but we provide the same technical assistance and training. Probably not as complex as maybe ASISTA would, but I'm sure you guys could cover any technical assistance. And we have training manuals, toolkits, how-to guides, checklists for you, samples. Okay. Other publications, and with citation and research. And as often as possible, we want to be able to cite to the Department of Homeland Security's materials, regulations and statutes. online learning modules that I can share with you, webinars, and also podcasts. And so before we break, we're going to cover one more thing, and that's VAWA confidentiality protections.
Yeah, and I just want to, as I get started, as I get started on this, I also want to mention that for special immigrant juvenile status, we also have a lot of training materials for judges that are particularly good on the family law side of this. So for example, we have a special immigrant juvenile status bench book for judges. We have TNU certification guides for judges and for police and prosecutors that are really helpful in the whole issue of U-Visa certification. So I want to give you a brief overview of VAWA confidentiality. Next slide, please. Is the only place in immigration law where it basically puts the brakes on removal of anybody, so that these laws can be used to protect immigrant crime victims from removal. And so I want to know how many of you have worked with survivors who have received threats of deportation from their perpetrators, who have been contacted by immigration enforcement officials, or both. We're seeing, give you a few minutes, about a third of you have responded. And while you're responding, I'm going to tell you a little bit about, one of the things that the social science data that we've done over the years has shown us is that perpetrators are actively involved in trying to get victims removed while their immigration cases are pending. So we see 50%, over 50% of you are telling us that you've had threats of deportation from the perpetrators. And 42% of you are saying not only have you had threats, but you've actually had your clients be contacted by immigration enforcement officials. Thank you very much for the poll. And that is right. Perpetrators are actively involved, and particularly when victims are limited English proficient, perpetrators have been increasingly effective at getting victims arrested when the victim calls to police for help. So it's important to know these VAWA confidentiality laws are the shield that protects immigrant crime victims from removal. And that's why we're talking about them here. Next slide, please. And so VAWA confidentiality has three parts. They have a bar on DHS officials using perpetrator, basically being able to rely on perpetrator provided information to remove the victim. They can't be based solely on it, but they're not supposed to basically say, the perpetrator told me she was undocumented and I looked in the system and I see they're undocumented and that's enough. It doesn't work that way. That basically, when perpetrators call and try to give tips to turn victims in, DHS is barred from relying on that information. And if they rely on it to harm a victim, to decide a case against her, to try to get her removed, they can be sanctioned for that. And that's what VAWA confidentiality protects against. We're going to give you some tips on how you can trigger, how you can make those provisions work better for your clients. And let me just say now, it's just easier because it's in my head, that basically you as a lawyer, if you give your VAWA self-petitioner, U-Visa, T-Visa, somebody who you're working with to file an immigration case, a letter saying she's in the process of filing an immigration case, and tell her how to safely carry that around. If she shows that letter to an ICE agent that maybe is coming after her because her abusers sent her, they have to stop in their tracks. They cannot, it will stop them from removing her, and it will make them have to go through a process of supervisor approval to do anything else to harm her. And it can lead to the any immigration case brought against her in immigration court being dismissed. Whoops, one more. I'm not ready for the next slide yet. Okay, there are also locational prohibitions. There are certain places like courthouses and rape crisis centers and other places where immigration enforcement can't happen against victims, There are other places that it can't happen against anyone, and we have lists of those too. And non-disclosure protections that are particularly important for family lawyers. Immigration lawyers need to know about them, so that, but they also, the family lawyers are the ones that will get perpetrators in family cases trying to discover what happened in the immigration case or the information contained in the immigration case. So we did this poll already, right? It's just sitting there. So okay, get rid of it. Next slide, please. So this is an infographic that kind of talks about the same things, but it just, what happens is the non-disclosure protections kick in, and the protections from deportation that come with these cases work most effectively once a victim is filed a VAWA, a T, a U, or any of the immigration cases that are types that are covered, battered spouse waiver. And so that's why getting something filed quickly can be crucial, particularly if you're going to serve the perpetrator with papers in a divorce case or a protection order case, so that if he reacts by trying to turn in, it stops ICE from going after her. Abuser protection from the prohibition, though, on use of abuser provided information technically begins the moment you have a marriage, a parent-child relationship, and abuse, battering or extreme cruelty, and the location provisions protect all victims. Next slide, please. And so and if ICE or immigration, any USCIS or any immigration official at DOJ, State Department, or HHS or DHS violate these provisions, it's a disciplinary action, and there have absolutely been demotions over this, and a $5,000 fine per case, and the violations can lead to dismissal of immigration actions, detention, immigration cases against victims. Next slide, please. And when you file your immigration case, they get registered in this centralized system in DHS called the red flag system that notifies immigration officials that your client is a victim. So they get notified if they have a case pending, and they also get notified if they're carrying around a letter from you saying they're in process of filing a case. Both of those help put the brakes on these. Next slide, please. DHS, so it protects the protections and the confidentiality protections in terms of the case files apply to VAWA self-petitioners, VAWA cancellation, suspension, battered spouse waivers, U visas, T visas, continued presence, and abused spouses of work visa holders who file for employment authorization. Next slide, please. So, and what's really important, again, for those of us that are kind of going to be in family court to understand is that if a victim shows evidence that they are in the process, and this is for all of us, process of filing an immigration case that gets VAWA confidentiality protection, any evidence, a protection order, a finding of domestic violence in a custody case, a copy of a U visa certification or a T visa endorsement, or this letter, all can notify immigration that she's a victim and they should not be bugging her. They should back off. And both, you can, NUAP provides technical assistance on this. People all over the country have my cell phone for this purpose. Call my cell and I can get to somebody at DHS usually within 24 hours or less if a VAWA confidentiality violation occurs. And I know ASISTA helps on those as well. Next slide, please.
So as we segue into that, has another quick poll. Has a perpetrator in family court, those of you that are family attorneys or that you've worked with survivors that are in family court, have they ever tried to raise his or her immigration status in a case? And then B, have they tried to obtain information about a survivor's immigration status through court discovery or both?
So this is really interesting, Rocio. I did a training in Florida for judges on statewide training for judges on this issue on Tuesday, and they are responding in exactly the same way you guys are, which is like 51% of them have seen this happen and 46% of them have seen both happen. This is happening all the time. It is like one of the most common things you as a family lawyer are going to see, and you don't have to be afraid of it. It is wrong, and they shouldn't be trying to use the family court as an end run around these VAWA confidentiality protections.
Yeah. And we also recently just did a webinar on that. So if you want to just kind of learn more about that webinar is available in our webpage. But here's the short answer, or the quick where you can look. In family law, the VAWA and the U visa case information is not discoverable. In criminal law, it's only the U visa case certification is discoverable. And that even goes with what you shared at prosecutors. We work really closely with our partners at Equitas, another TA provider, and they help us with very complex TA to help prosecutors on that. But what we hear sometimes in TA is a prosecutor wants a copy of the U visa file. What do we do? And so there it's important to not give that out, because once it's in their possession and control, then they do have to share it. So it's good to know that only the certification is discoverable. And in civil cases, it's not discoverable except potentially as it's needed to prove damages to a specific individuals. And that's an in-camera view for the judge, which can be redacted. Here's a list of the sensitive locations that Leslie shared with you earlier for specific that are to protect victims, and those include the shelter, rape crisis center, the supervised visitation center, victim service provider, a community-based organization, and then the courthouse when you're there in connection to a custody case, civil, domestic violence case, trafficking or stalking. And these are important to know as a family lawyer. Where are places that could be good, safe exchange places for survivors exchanging the kids with an abuser? And so these are a good place to start as to where a safe exchange can occur without fear of immigration enforcement. Other lists, and this is that covers everyone else, whether they're a survivor or not, it would be schools, medical treatment, healthcare facilities, places of worship, and during a public demonstration, march, rally, or parade.
Can I just add something? There's a July 2022 policy on, October 2021 that came out that expanded this to any place where children are generally present. It covers churches and faith-based organizations. It's much broader, and we can get you a copy of that, but there are a lot of places that expand options for both visitation exchange and where your clients can safely seek services.
And just like that tool is available on our website, there is a VAWA confidentiality tab. I shared with you a quick brochure on the 3 prongs of VAWA confidentiality. That's a simple, but we also have from simple one-pagers to more complex areas of how this VAWA confidentiality can keep immigrant survivor safe, collection of federal laws, regulations, and policies, up-to-date case law that we used just in October for the last webinar that we had on that, and a how-to step-by-step guide on how to counter and respond to VAWA confidentiality violations, manuals, and then the technical assistance that Leslie talked about.
And here at ASISTA, I put some links in there for you. Those are some live links to the resources on our website. And also resources, again, some of it is housed at AIS, the Alliance for Immigrant Survivors that I mentioned. So check out those links. In addition, of course, we have the case-specific TA and interventions, etc. Flag for you that we do have something called emergency TA at ASISTA, which we ask that you use judiciously and only when it's a real emergency, but it is there for those emergencies. So if you have something going on, we will jump on a Zoom with you, and we'll talk later about how to access all that, but know that we know sometimes these things come up quickly and are very time sensitive. So that's an option for you as well.
Great. So this is a good time for break. When you guys come back, we're going to talk about all the support services and public benefit services that are available to survivors, and some family law issues to keep an eye out for, protection orders, and with a brief eye view of our resources. And so with that, it is well, depending on where you are, it is the hour. And so let's take a 10-minute break, and we'll see you 10 minutes after this hour.
Are we back?
Yeah, like we're
back.
welcome back from break, everyone. We're going to get started just so that we can make sure we cover everything, but we do have these slides available for you, and this for you to refer to, even if some of them are just here for you to reference at a later date. So let's get started on what public services and public benefits are available for immigrant survivors. These lists are both documented and undocumented immigrant survivors can access, and that includes legal services that in many states is called legal aid, but there's no restrictions for immigrant survivors or not. I know in my when I started to practice, it was said if they did not have a social security number, people in legal aid were not able to help the survivor. And there's exceptions that if someone's a survivor of domestic violence, sexual assault, or other crimes, and Leslie will explain, they are able to access legal services, family court, language access, police assistance, protection orders, have child custody and support, have their abusers criminally prosecuted, transitional housing, WIC, school lunch, immunizations, private and secondary education, and then care from migrant health clinics and VOCA funds. That's the Victim Assistance of Crime Act funds available from the state. And it comes in list of required services, which includes in-kind services, those provided at the community level. These are services that are not based on an individual income or resources, and all the services necessary to protect life and safety. That includes, like police, fire assistance, shelters, like many of our programs, emergency Medicaid, school lunch, WIC. This is the list of in-kind services available to documented and undocumented immigrants, which includes child and adult protective services, crisis counseling and intervention, victim assistance, treatment of mental illness or substance abuse, FEMA, adverse weather conditions funds, soup kitchens, community food banks, shelter and transitional housing, and nutrition programs. Now, remember the statistics when Leslie showed us how there's mixed status families. It's important to know that sometimes survivors that we work with, their children will qualify sometimes, especially if their kids are U.S. citizens and the parents do not. And in that case, they can still access that benefit. If a child qualifies as a citizen or as a qualified immigrant, the agency giving that benefit can only ask about that child's eligibility. So it's important to talk to survivors about that they may be asked about their immigration status, but they should only be asked about the child's eligibility. And no question may be asked about the immigration status of the parent. That's where the parent should say, I'm here applying for this benefit for my child, and they should not answer questions about their immigration status.
And so what happens is all of the benefits and services, including legal assistance that Rocio was talking about earlier. So it's important to understand legal assistance in particular, if you're OVW funded, which you guys all are, there are no immigrant restrictions on your OVW funded work, and that some of you may work in Legal Services Corporation funded programs, whereas to survivors, there's no immigrant restrictions. and that there are that you can do any kind of work related to something that would overcome or mitigate the abuse. In addition, though, to all of those things that are available to everybody, there are, as victims begin filing for immigration status or gain different kinds of legal immigration status, they gain greater access to public benefits. And so under public benefits laws, the qualified immigrants include lawful permanent residents, some for U visas and SIJS children, they will only be qualified immigrants once they become lawful permanent residents. Asylees and refugees, VAWA self-petitioners, trafficking victims with continued presence or bona fide determinations in T visa cases are also eligible, are also qualified immigrants. People who will have less access to federal, and so there was a law in 1996 that passed that basically gave states the opportunity to offer more state-funded benefits to victims than the federal standard level, or to pass a law that takes away benefits in that state that would otherwise be federally available. The vast majority of states have given more benefits in certain areas, and some states have taken them away. So it makes it a bit complicated, but generally speaking, U visa applicants, DACA recipients, U visa recipients, asylum applicants, people on work and student visas have the least access to federal and state funded public benefits. Next slide. And what benefits the immigrant victims qualify for will vary by immigration status, with VAWAs and Ts having more access than Us and SIJS. When a victim entered the United States, so people who entered, and you may see this, people who entered before 96 have more access than people entering after 1996. So you could be working with young adults who came over at age 2, who are pre-96 folks, who will have more access than some of their older, some people who entered more recently. And certain programs, each benefit program is different. We on our website, we're gonna show you in a second, we have 30 different benefits and services that we're tracking: WIC, VOCA assistance, TANF, food stamps, all these different kinds of benefits. And so whether a victim is eligible for a benefit depends on the heightened program requirements that each of those benefits come with, and what benefits are offered by the state. So we have a brand new state public benefits map. Doesn't quite look like this anymore. It's much more interactive, and it's available so you can easily look up, next slide please, what your victim qualifies for all of these different kinds of benefits and services by immigration status. So VAWA self-petitioner, and we have an online version where you can tell the difference between a U visa applicant, a U visa bona fide or waitlist approved, and a U visa recipient, a lawful permanent resident, a battered spouse waiver, a VAWA self-petitioner, an Afghan asylee, whatever, Afghan refugee, whatever it is, we have them divided by 15 different kinds of immigration related relief and 30 different programs. Next slide, please. And so what's important is with this information, one of the things that's really important is you never want to be in a position of sending an immigrant survivor, or whether or not they're LEP, to a benefits agency to apply for themselves or their children by themselves, because the benefits workers often don't know what they're going to qualify for. And our benefits charts lead to these giant, like 40-page charts per state, which have all of the federal law, all of the state law citations, and you make it easy for you to kind of download the documents that show why this self-petitioner in my state is eligible for TANF. And so they don't turn her away when she's eligible, and they don't ask questions they shouldn't when she's only applying for her kids. So it's a good advocacy opportunity. Next slide, please. So what would you want to take with you when you are applying for a public benefits from a public benefits agency for an immigrant survivor? Is it a copy of the state or federal statute, documents showing that your victim is eligible, like the VAWA self-petition or the approved U visa or the SIJS application or something like that, or the relevant state or federal policies, or all of the above? Looks like 90 some odd % of you so far are saying all of the above. That's correct. And we are, through our public benefits maps and charts, you can easily access that information, and we provide lots of technical assistance and support if you want to know which doctor to take with you to go to advocate for that, to make sure that not only does the victim get what she's eligible for, but she and her children both get what they're eligible for. Next slide, please. And the other thing that I think is really important, and I think it was mentioned a little bit earlier, I think Kristen, you mentioned it, we were talking about public charge as an example of where there's materials through AIS. We also have, one of the things we did in VAWA 2013 is we made VAWA's T's and U's exempt from public charge. And this is a list of people that are exempt from public charge. So public charge generally, if you're working with a crime victim, is not something you should have to worry about. But again, in order to get the exemption, they have to file one of these kinds of cases. So this is aware for the immigration attorneys in the room. If you have a client and the husband's filed papers for her and she's got a conditional green card and she needs to file either for divorce or a battered spouse waiver, if you proceed by divorce, it could be a problem. If you proceed through the battered spouse waiver, you got a public charge exemption, because battered spouse waiver victims are considered VAWA self-petitioners under immigration law. So we have, no, it's great. The resources available, as I said, the public benefits maps and charts. We have a separate set of charts just looking at post-assault healthcare, prenatal care. It's actually prenatal and child health care, forensics exams, what Medicaid covers in each state, what emergency Medicaid covers in each state is available. We have lots of training tools on public benefits access for you.
And another really neat tool that we have is a directory of service providers. And so from the link of our materials is this directory. And I would invite you to put in your organization if they're not there already, or update your information. And this tool is really neat because if you have a survivor that is leaving the state or the city that you're in and they're moving somewhere else, you can connect them with resources. Or if you want to know what resources are around you, this will give you that information, and it's broken down by the type of need that they might have. So if it's a family law lawyer or immigration lawyer or shelter or organization. So go ahead and put your organization there, and then and update your information.
And just a few tools to help you from ASISTA. Again, that's a live link to public charge on our website. All these links should be in your materials as well. I wanted to flag for you a recent webinar that our friends at the Asian Pacific Institute on Gender-Based Violence did. It was just in October. You may know there was a rule recently, a final rule on public charge, and they did a fantastic webinar on the implications of that rule for immigrant survivors. And if you click, that's a live link as well. If you click that, it'll take you to the slides, the recording, an advisory they did on this, and they've really been leading on this issue as well. So really recommend that. And again, more resources for you, actually oodles of resources for you on the AIS website. So that's a link as well. In addition to, again, the things that we usually provide at ASISTA, TA around this, listserv, etc.
So to talk about the family law issues, we want you to be able to identify these and work together with family law attorneys, because they might have information that can be helpful to keeping the survivor safe and also for their immigration applications.
Right. So we're going to talk now from a family law perspective. And another thing I wanted to mention, one of the tools NUAP has developed over the years has to do with a trauma-informed interviewing tool that has really good information, that collects really good information about trauma and the history of victimization for immigration cases. It was designed for self-petitions and U visas. We have a tool that helps family lawyers use the same document, portions of it, that are super helpful in preparing for your family law case. What I'm gonna do now is just go over some of the big issues that come up for immigrant survivors that we have tons of tools on in family court cases. The first one is jurisdiction. So there have been cases and times and TA questions over the years where perpetrators of domestic violence are trying to kind of say the victim can't come to court. She's an immigrant, our courts aren't open to immigrants, I'm a citizen, I win everything because she has no jurisdiction, kind of thing. And there was a next slide, there's a very recent, this came up most recently in a case in Nevada where we got a unanimous ruling from the Supreme Court in Nevada. This came out of a legal aid case. I believe it was an LAV grantee originally, a legal aid of Southern Nevada, which is Las Vegas, in which a perpetrator tried to argue that a victim couldn't file for divorce and get custody of their children because she was an immigrant. And the Nevada Supreme Court basically said residence for divorce purposes has nothing to do with immigration status, essentially, and that visa holders and other temporary residents from an immigration law perspective can establish residence for purposes of divorce in Nevada, which is what every other case that never reached this level in their case at the trial level has been happening nationally. Next slide, please. In terms of impact of divorce, there's a couple of points I want to make. One of the things that you will see, so divorce as an immigration law issue can cut off people from immigration relief. So it's not benign. So if a client comes in and they've been sued for divorce and it turns out they're foreign born, you're gonna want to make sure that if you consent to that you may have to get continuances and do some other things to kind of slow down the divorce process if you have somebody for whom the divorce could cut off their access to lawful permanent residency or their continued access to a visa while you begin the process of filing the immigration case for that victim that then can preserve it. So it's just know that it should be a red flag when somebody comes in and you want to check to make sure you don't do anything in the divorce case that's going to cut the victim off prematurely from things like they might have work authorization that they could lose and have to kind of go back from scratch or wait a couple of years to get it again, that you could avoid depending on how you handle the divorce case. Next slide. The other thing to be really concerned about is annulment. You see all these weird stuff where, 10-year marriages, 5 kids, he's not Catholic, and he walks in to get an annulment instead of a divorce. Anytime you see that as a family, and it may not be 10 years, it may be 2, it may be 1 child, they might be Catholic, whatever the story is. An annulment instead of a divorce for an immigrant survivor could be problematic because we've seen technical assistance cases where the victim will agree to her lawyer said, okay, fine, I get what I want. They work out custody and they agree to the annulment. And then the perpetrator takes that agreement to the annulment into the federal prosecutors and gets a U.S. attorney to sue her for marriage fraud. And so don't agree to it. Don't do it. It is not benign. And you should just be filing for a regular divorce. And again, we're training judges on this too. I don't know of any cases that we've worked on through TA where it hasn't come out with a divorce instead of annulment once we've worked with the attorneys. So it's something to be aware of. The other thing that's important to be aware of is in immigration law, there are things called affidavits of support. And that when a US citizen or lawful permanent resident files papers to sponsor a family member for immigration, they fill out something called an affidavit of support. Those affidavit of support, for one, judges love them, state court judges, from an evidence perspective, because when somebody fills out an affidavit of support, they're providing all of this great information about their income and their assets, how much money they have, because they're basically wanting to show DHS that they can support all these family members they're trying to bring over. And it's amazing how what they're telling the DHS differs from what they're going to tell your state court judge when you go in for child support or spousal support. It's like night and day. And so when there's an affidavit of support, you should know there's all this evidence in the immigration case that can help you prove his ability to pay in a child support or a spousal support case. Not only that, next slide, please, is that courts will enforce the affidavits of support. They will use the evidence of them in state courts. They will use them to set child support levels. They're a contract between the abuser or the sponsor. In our case, these are domestic violence cases, so the abuser or the sponsor, and the DHS. And so, and it's an agreement that the victim can enforce in divorce proceeding. And divorce, estrangement, prenuptial agreements don't terminate the effect of the ability to obligations under the affidavit of support, and there's no statute of limitation on enforcement. Not only that, next slide, please. Divorce it lasts until the person is the non-citizen either naturalizes, has 40 hours of work credit, 40 quarters, not hours, of work credit that can be credited to them under the Social Security Administration until they cease to be a lawful permanent resident or until they die. And divorce, if divorce doesn't necessarily end the ability to enforce the affidavit. Next slide, please.
And we talk about these topics and other interesting topics in our virtual community of practice with family lawyers. We meet every month, and it's the group that drives what and the emerging issues that you're seeing that drive the conversations and what you learn. And if you're interested, here is the link. I'll put it there in the chat. Email me and we'll get you right on that group.
And we have a brand new affidavit of support, like a brand new divorce bench card. And we've done a whole review of case law in this whole area. So it's all available for you that we and our consultant, Veronica Thronson, have done. So now we're going to highlight a couple of issues that come up in protection order proceedings. The first thing you should know is that if your courts say, oh, people can go file for protection orders by themselves, they don't need lawyers. Immigrant victims, first of all, almost never apply for protection orders without the help of a lawyer or a victim advocate to support them. And that's often because they don't even know protection orders exist until they walk in your door or the victim advocate agency that you're working with. Next slide, please. And that all persons are eligible to receive protection orders without regard to immigration status. Protection orders, the domestic violence definition, as I mentioned earlier, is broader than state protection orders, so that many victims will qualify for self-petitions who don't even qualify for protection orders. But with the help of victim advocates, immigrant victims are willing to get protection orders. Next slide, please. And they're effective in protecting them. One of the big things that will happen, and I guarantee you this will happen if it hasn't happened already, In protection order cases, abusers will say, I can't have a protection order issued against me because I'm gonna get deported. Not true. Issuance of a protection order has no effect on immigration status. However, a finding of violation of protection orders, and we're talking about the provisions in the protection order that deter abuse, is a deportable offense. And one of the things that is not happening commonly that you should play a role in making happen is courts should be doing Padilla advisals on protection order cases all the time, because it helps make the orders more enforceable and it informs the perpetrator about the ramifications of violating the order under immigration law. Next slide, please. And the other big issue is that there's real dangers. Like, there'll be cases where you'll file for a protection order and the perpetrator will come in and say he's filing for a protection order against her, or each party is filing against the other. And it's really important, if the client you're representing is the victim and not the primary perpetrator of abuse in the relationship, it is super important not to allow your client to agree to the issue of protection order against them. Because if protection order is issued against a victim, what we have historically seen is perpetrators are very successful in trying to get those orders enforced against victims. Because if they can convince the judge to issue one, it's not hard to convince that they've been violated. And you never want to have, the way I used to deal with these cases when I was litigating it, I treat them like murder cases. I would go to trial to fight to make sure that my client, who was the victim, never had a protection order issued against them. We do tons of technical assistance on this and are here to support you on that. And there's lots of reasons that having a protection order issued against a victim can be harmful in terms of a victim. It can make her self-petition much more complicated. It could potentially interfere with her ability to get a cancellation of removal. It could make naturalization more difficult. You want to avoid all of these if you're working with a survivor. And these are the implications. Let's say you have, if a perpetrator violates the order, when they go to do a background check for naturalization, the fingerprints, that's how they'll end up potentially being deported.
And so
go ahead.
Yeah, while we talk about creative remedies, immigration survivors have unique challenges, and sometimes there are some creative remedies that you can do to keep them safe. And so while Leslie tells you about creative protection order remedies, those of you that have experience getting creative remedies for clients and protection orders, go ahead and put them in the chat. And Leslie will tell you a little bit about why it's important to be creative.
Okay. So yes, and when I say creative, I'm talking about remedies where you're seeking remedies for your client that go beyond the 4 square corners of what's in your statute. So, custody, stay away, child support, pay for change of the locks on the house. That's not what I'm talking about. So we're talking about anything. This is a way you can also be really culturally competent, because you can work with your client to figure out what are the buttons he's pushing, what are the things that might be embedded in culture or religion or other things that he's using to control her. And you can work creative with your client to request remedies that interfere with his ability to continue doing that. That's what we're talking about with creative remedies. And the law in this area says the courts can order anything that is designed to curb future abuse or to remedy abuse that's already happened. And there just needs to be a nexus with the victimization. Next slide, please. One of the things that's most important, and now we're going back to the stuff we were talking about a little while ago in immigration, when you saw that 61-month delay between filing and work authorization in the U visa case, or the 2-year delay for self-petitioners who are abused by their lawful permanent resident spouses. What happens during the delay? Well, what our research tells us, and what many of you probably see, is you have domestic violence clients who stay with their abuser until they get work authorization. Many. And so what's good to know is in every state, you can get a protection order that says no unlawful contact. You can get a protection order that allows them to live together, but says do not molest, assault, threaten, physically abuse, sends them to batterer's treatment. And that, you know, basically this helps the victims who go back and forth, and that helps the victims while they're waiting for this immigration case to wend its way through the system. So don't be afraid of these. Don't think that they have to be separated to get a protection order. And there's a whole range of creative remedies that can be designed to stop the immigration-related abuse, to obtain the documents that you need for your immigration case, to prevent international and state-to-state parental kidnapping, to get spousal support, child support, money for make him pay health insurance, money for, you know, other things he's broken or fixed her car, whatever the story is. Protection orders can be creatively used for that. And the next slide gives you an idea of the range of things that the abuser may have his hands on that you can use the protection order to get, which would help out in the victim's immigration case. Rocio, why the love letters? Like, what is that? What are those things? You know, why do I care about that? That's not like normal in a protection order. Why would I want it if I'm working with an immigrant victim?
So those love letters were great in showing that there's that good faith marriage. And so all this list of evidence, remember, if you're an immigration attorney, to work with that family law attorney, because they can really help you either in the protection order part of the case or family law part of the case, get some of this evidence, because it'll be really key to making a strong case before immigration.
Yeah. And we have, for protection orders, we have evidence checklists. We have chapters on protection orders, not only for domestic violence, but for sexual violence victims as well. We have chapters on all the different kinds of evidence and the way to think about these cases for both domestic violence and sexual violence survivors. So, and protection orders, really interestingly, even over the years, and I've seen this through the 90s into up till today, that, you know, immigration enforcement goes up and down, and people, sometimes it's more scary than others and more likely than others. But one of the things is we see is that with help from victim advocates and attorneys and support, immigrant victims use protection orders when they've stopped doing everything else because of the advocates and attorneys they work with. So they are willing to get them, and they're effective, sometimes as the only thing they're doing. And maybe before they filed, or they might be afraid to file their self-petition, or the immigration case might be taking longer, and the protection order is the thing that they can go do that keeps them safe, helps keep them safe in the meantime.
Yeah, and we also get questions about immigrant survivors and custody, and we can support you with that. This is a really short piece of what we can offer, but
so the biggest issue here, this comes up all the time. I literally, just before I got off, was on a training with judges who were telling me they're seeing this happen in their courtrooms all the time. And so it's really important. We used to, in the old days, as family lawyers, walk in and say, immigration status isn't relevant to custody. Well, it's actually more complex than that. Immigration status, what is it relevant to? If I want to go in and show that my client is married to a US citizen and he's never filed papers for her, and it's been 10 years and he's threatening to deport her if she does this or that or the other, then I'm going to go in and show, I'm going to want to demonstrate immigration-related abuse, power, and control as part of the domestic violence in my custody case to help explain to the judge that when he says, I need custody because she's undocumented, not working because she doesn't have papers, that the reason I don't have my client doesn't have work authorization is he made sure she didn't by not filing papers for her. And so you can turn it, so it's relevant to the power and control. It's relevant to how he was using it to control her immigration status. It's relevant to his threats of deportation. and to part of the history of violence that will affect the child custody determination. However, it's not relevant to who's the primary caretaker, what are the evaluation of parenting skills. No state statute has the child's anybody's immigration status as a best interest factor in the state. And that it's relevant to requirements regarding, it's not relevant to whether an abuser gets the child or not and what your state laws say about abusers access and control of children. There are 4 big myths that we see where judges get it wrong, even in reported decisions around this. The first myth is that deportation is imminent, which is not true, as you'll see in a little bit. In terms of, DHS policies that are written, and there are policies and forms of immigration status that protect victims from removal. So the fact that somebody's undocumented doesn't mean they're going to be deported. That's not true. The court, sometimes the perpetrator will say, well, she's undocumented, so she's going to flee the country with the kids. Also not true. The people most likely to flee the country with the kids are dual nationals, people with legal status who can flee, who can travel freely to and from the United States, and people who have been making threats of kidnapping. And this is State Department data. Oops, 2 back. I'm not ready yet. They argue about no livelihood. They say she doesn't have a livelihood. Well, the courts can remedy that by ordering child support and other forms of immigration relief. And the last one you'll hear, another one you'll hear, is they'll say, I'm the citizen, you or lawful permanent resident, you have to give me custody or I can't file immigration papers for my kids. Total lie. Custody has nothing to do with whether a citizen or lawful permanent resident can file immigration papers for their children. Next slide, please. This is a decision out of the Nebraska Supreme Court in which actually an immigrant mother's parental rights were wrongly terminated. And it's really got great case law in it that describes, I can't see the slide anymore. That describe, okay, I'll wait for a minute. Can you go back a slide, whoever changed it?
Yes.
That parents have a constitutional right to custody absent unfitness, that this constitutional right applies to parents without regard to whether they're undocumented, have a vow of self-petition, whether they're deported, whether they're detained. There's an overriding presumption that the parent-child relationship is constitutionally protected, and that the child should be placed with the best interest, in the best interest of their. It's a child's best interest to be placed with their parent, and no court should entertain a comparison of natural versus adoptive parents, cultures, countries, financial means as part of determining whether or not somebody should have custody. A really good, powerful, very helpful case. Next slide, please. You want to take this one, Ro?
Sure, yeah. Which parents are most likely to be subject of immigration enforcement? And you can answer that while Leslie tells us the data.
So don't give me the answers yet. Don't give me the data yet. We can stay there and give them a second. I think we only have 12 minutes to go. Okay. Yeah, so okay, so most of you are saying people with criminal convictions, people with removal orders or notices to appear, undocumented parents and lawful permanent residents to a certain extent. Okay, now next slide, please. And so the answer, which you could show as you're still doing this, is the people most likely to be removed are essentially people with criminal convictions. If you're working with a client that doesn't have, and it's not all criminal convictions, there are moderating factors here, like victimization, like being the primary caregiver of children, and that DHS is required to look, ICE is required to look at the totality of the circumstances. And so unless you have if you're working with a client that is an open removal order, meaning they've been ordered removed, you got to call ASISTA as soon as possible. And get them to an immigration attorney. That is not something that a legal services attorney who hasn't done immigration should be dealing with. But absent that, most of the clients we work with are not in this position. Next slide, please.
Yeah, and then here, another poll, but who is least likely to flee with the children from the United States? A, US citizens, B, undocumented immigrants, C, dual nationals, and D, multiple entry visa holder parents. So right now we're seeing a lot of you saying undocumented parents are most likely to flee.
Okay.
And
And
you
the
remember-
answer is, next slide, that's not correct, actually. Undocumented parents are the least likely to flee. Next slide, please. Who is most likely to flee? This is the State Department data I was telling you about. People who threatened abduction, people who are engaging in plans of abduction, people engaged in domestic violence and stalking, and people with the ability to freely travel back and forth in the United States. Dual nationals are really scary in this respect. So there's really good data on this. And you should, if somebody's going into court to say that your client's gonna snatch them, show them that they have no plans, that they've never left since they first entered the United States and things like that. Next slide, please. And that you can seek from family court judges specific written orders designed to prevent parental kidnapping. These can be very effective, not 100% effective, but they really can help. And you also want specific orders that establish the parent, like the marriage and the parent-child relationship and the fact of the abuse, because they're going to help with the victim's immigration case. Next slide, please. So just a few kind of high points as we come towards the end of the presentation on child support. So it's very interesting. It's important to understand how paying child support helps an immigrant parent. Payment of child support through the court gives any non-citizen parent a history of child support payments, or whether you're the payor or the recipient. If you get them through the court, you as a parent who sought the support for your child can show that you're a person of good moral character and you're trying to secure support for your child. If you're paying child support, it also contributes to being able to show good moral character for the non-custodial parent, who at some point is going to need to show that if they have a VAWA cancellation case, they're seeking naturalization, or obtaining some kind of other immigration benefit, where they have to show hardship. And if they're paying child support, it can be easier to establish that. Next slide, please. Lack of legal work authorization is not a valid defense to paying for non-payment of child support. Sometimes perpetrators in some of my cases would walk in and say, I can't legally work, so I can't pay child support, even though they're earning $50,000 a year as a chef or something. And so that, that isn't a valid defense. There's good case law on this, but the judge can't order somebody who's undocumented to undertake a job search. They can impute income, they can look at their history of earnings, et cetera. And they can look at the fact that people who, the non-custodial parent who's actually working could go get an I-10 and pay taxes and have documented record of their earnings. In wage withholding cases, there have been cases where a lot of us have had clients where who are they working for? They're working for their uncle's business or their cousin or their father or their brother. Some of those cousins, brothers, father's business have refused to pay wage withholding. When that happens, state courts have said, nope, it doesn't work. You have to pay the child support that you failed to withhold. So that doesn't work. Next slide, please. And wage withholding gives them a good, and the last thing is proof of an undocumented worker's income gets tricky. We do a lot of TIA on this. We have some great bench cards, and there's lots of different ways to get at that earning potential for purposes of child support awards. I'm going to go back to Kristen and Rocio to wrap up.
Yeah, just summary, we have a lot of resources on every one of these things. I invite you to join the community of practices. and access our webinars. We will send you invitations when we have new webinars. If there's something you want to learn or emerging issues that are impacting you or tools that can help you with your work, please do come send me an email. I wish we were in person. I could get to talk to you and you'd see how approachable that we are, but I hope that we were able to do that here today. But we're really here just to support you. And though it was a lot to cover, I hope it just gave you a little spark of how we can support you.
And may I ask, just before we switch to Kirsten, one of the things I want to highlight, I saw that many of you might be like paralegals or might be the financial person on the grant, et cetera. We're going to submit, if you could help. So we have an outreach list that we will send information out to you. And if there's the other people who might be more appropriate, let's say the family lawyers or the lawyers doing public benefits, the lawyers doing immigration in your agency, please have them reach out to us or send us their emails so we can get them signed up on the list. So for those of you, the grant manager people, please forward what we send you to other people in your agency, but also encourage them to sign up directly, because we don't want our ads for great training opportunities to kind of fall through the cracks in the email issues. So I just wanted to mention that as well.
And the same is true for us at ASISTA. We want to make sure our stuff is getting to the right people. So that flyer that is on the slide there is a link. I would love for you to check it out. It gives you really good info on how we can help you. I want to really flag for you, we will have a webinar coming up to orient our new OVW LAV grantees or returning grantees. It's a good refresher. This is an excellent way to connect with us and just figure out, like, take an hour with us and figure out how it works to get into the loop so you have access to everything you need. Our tentative date is going to be Thursday, February 22nd, 12 to 1:30 Eastern time. We'll keep you posted on the actual date. We think it'll be then, but we're just confirming. There's our resource page. Again, that's a live link that's just for our OVW grantees. It includes our YouTube channel where you can see all of our previous trainings from this grant cycle and grant cycles before that. Next slide, please. The TA that we do and the interventions, that happens through video call, like through Zoom or Google Meet. If you have an accessibility reason why that's not possible for you, we will work with you on that, no problem. Many of you may already have an account with us, and if you do, we would love for you to not create a new one. My colleague Maria's contact info is there. Just contact her and she'll get you updated. That'll give you access to our TA portal where you can go in and schedule your own time for those TA appointments, as well as access to the experts listserv. We can keep rolling here. This is a sample. Again, these are all live links. If you want to watch these, check these out. These are some recent past webinars that we've done just in this grant cycle. And some of them are with our MOU partners, Casa de Esperanza, Esperanza United, their new-ish name, API GBV, and Ujima, resource for survivors in the Black community. So many of them, most of them are available in Spanish as well as English. So we'd love for you to check those out. Here's next slide. The next one that we've got coming up is this one that you may find helpful. That's coming right up on January 11th. We'd love to see you there. That link is to just go ahead and get registered. So if you want to click that, let's see what our next slide is. If you prefer on-site TA and or training, we have some limited ability to travel or do something virtual for you. So we might be able to come to your community or create a custom virtual training for you. Our staff attorney who primarily handles our OVW stuff is Kelly Hatt. She's also wonderful, and you can contact her to request that training for your community. And I think we're getting pretty close to the end here. These are some written tools. Again, those are all live links. We'll do the next slide because I think we're running short here. There's, again, link to our website. You can find all this stuff. Contact me directly if you like. Contact Kelly, contact Maria. We are here to help you succeed in serving immigrant survivors who are your clients. So thanks.
And I would be remiss if I ended this without telling you, we're going to have a live in-person 2-day conference. There'll be two conferences back to back, a Monday, Tuesday, and a Wednesday, Thursday, designed for LAV grantees, among other OVW grantees, in person in Boston. We're waiting for the conference approval form to come through. But we should know hopefully in the next couple of months about it. It'll be the last. So if you want to save the date, it's the last week in August, Monday, Tuesday, Wednesday, Thursday, two different back-to-back trainings in Boston, Massachusetts. So you have travel money in your budgets that'll hopefully you'll put an earmark on so that you can attend. We can take about 75 grantees each conference. So it'll be 150 slots altogether. So hopefully you'll join us. Thank you.
Thank you all for the presentation. It was wonderful to hear you speak as always. Everybody, we're going to go ahead and take about a 10-minute break. So let's resume around 3:10. Thanks.
Thank you.
Thank you.
Hi, Leslie.
Hi, Mari Carmen. I was like, faces. I see faces. Hi, Lana. Okay.
Hello, and thank you.
You're welcome. Any of you have last questions for us, we can answer in the chat or personally while we were in the break, but I think we're good.
All right, I think I'm going to try to start sharing and make sure I work out the kinks on our little slide presentation, but so good to see you all.
Good to see you, Mari Carmen. Good luck.
Thanks,
Bye.
Leslie. Bye-bye.
Mari Carmen, those look great.
Okay, good. I was wondering if it was on, and just gonna make sure I can see the chat as well.
Yeah.
Perfect. If you guys have any questions as you're getting set up or have any tech issues, just let me know. I'm here, as is Annette, and we can help you work through things.
Sounds good. Thank you, Miranda. I think we're good. When we do ask for a breakout room, do we just like say it to the world? It's like, we're ready for a breakout room now. Just wanted to make sure if there was anything else that we needed to do to alert you when that happens.
Nope,
That
that's
is a great.
Perfect. Okay.
Thank you, Mari Carmen.
Sounds good. I will go offline just briefly and come back and join y'all and just at 3:10. So
Sounds great. See you then. All right, everyone, welcome back from the break. It is 3:10, so we're going to go ahead into our final presentation of this long 4-day stretch. Bring your energy, bring your excitement. They are ready to talk to you, and I'm sure you're ready to hear this last presentation. With that, I'm going to hand it over to the Tahirih team.
thank you, Miranda, and good afternoon, everyone. I am so excited to be here and joining you, and congratulations on being on your last session and the last day of your new LAV grantee orientation. We are just so excited to be here with you. I know we have colleagues on the call, and I joined just a little bit earlier and noticed many of my colleagues from Texas Rio Grande Legal Aid, where I was employed before. So excited to see each of you and welcome you to talk to you about population-specific trauma-informed lawyering. My name is Mari Carmen Garza. I'm the Chief of Programs at the Tahirih Justice Center. And joining me today is Morgan Weibel, Executive Director of our San Francisco Bay Area office. And we're going to share some information of the work that we do at Tahirih. Make sure I can advance slides. There we go. Just a really quick overview of the agenda and the information that we will be covering with you today. We're going to start with introductions. I know some of you may be familiar with us, but others may not. So we want to share some of the background, who we are, and even teach you how to pronounce our name, our organization's name. Then we're going to dive into what is trauma. We want to also do a compassion exercise with you. We will seek to take a little bit of a break after that exercise and then get back in and talk about what the trauma-informed approach is, how to work with interpreters, and then complete our time with you by speaking about vicarious trauma and self-care. Morgan.
All right. Well, as we introduce our organization, we'd like to invite you all to introduce yourselves in the chat as well. So if you would please go ahead and type your name, preferred pronouns, and let's go with, if you were a weather pattern, what would your weather pattern be right now? Is it sunny? Is it rainy, foggy, cold? Just give us a little pulse on how you're feeling at the end of all of these training sessions. And while you're introducing yourselves in the chat, I also want to do a quick shout out to my Tahirih colleagues on the call, including Anushe, Barfance, Daniela, Molly, Caitlin, Brittany, Alexis, Payal, Megan, Natasha. And a final thank you to Rachel Sheridan, who is our litigation counsel and a TTA funded attorney, who put together these beautiful slides and this entire training, and unfortunately is ill, so she's not here with us today. So Rachel, we hope that you're feeling better, and I'm going to thank you in advance for your grace in following me through this and your patience as I sub in for my colleague Rachel. So let's go on to the next slide. A little bit about Tahirih as an organization, how we were founded. The founder, Layli Miller Moreau, was a law student at American University. And during a summer internship, she was assigned the case of a woman named Fauzia Kasinga. So Fauzia was from Togo, West Africa, and she was seeking asylum here in the US after refusing to undergo FGM, or female genital mutilation or cutting. And she also was refusing to marry a man about 3 times her age who already had 3 wives. So when the immigration judge denied Fauzia's case, Layli convinced her law school clinic to take on the appeal and supported the legal team as they fought to establish, for the first time, a legal precedent for gender to serve as a basis for asylum here in the US. Layli and Fauzia went on to write a book together about the entire experience. It's called Do They Hear You When You Cry? Trigger warning, the book is a wonderful read, but it does detail all of the traumas that Fauzia experienced, including a prison riot while she was here in the US awaiting her asylum claim. But essentially, Layli took her portion of the proceeds of that book and founded the Tahirih Justice Center in 1997. So let's go on to the next slide. All right, here's where we're going to do the pronunciation game. I'm sorry, it is cheesy, but it will help you remember how to pronounce Tahirih. So if you say hooray and then put a ta at the beginning of it, Tahirih, that's how the name is pronounced. So feel free to unmute yourselves, come on for a second and just shout out Tahirih or hooray. I know it's been a long day. You're
Hooray,
welcome.
hooray.
Yes, thank you.
Tahirih.
Tahirih.
Awesome. Thank you all for joining. All right.
Tahirih. Yes.
Yes. When you have a difficult name, you have to come up with those things to help people remember how to pronounce it. So let me tell you a little bit about who Tahirih was, because she's actually a historical individual, a powerhouse of a woman, and the Tahirih Justice Center is named after her. So she was a 19th century Persian woman who was persecuted for her Baha'i faith and her advocacy for gender equality. She was born in 1814. She was an exemplar of women's strength in Persia at a time when most women were kept illiterate and hidden from the public sphere. She's remembered for her renowned skills as a poet, her theological insights, her leadership as one of the earliest Baha'is, and her ability to organize and inspire women to reject their oppressed status. In fact, in a disturbing parallel to what we just witnessed with the execution of Mahsa Amini in Iran, Tahirih was executed because she unveiled herself before a group of men. Tahirih's execution happened within 2 weeks of the Seneca Falls Conference here in the US, and she serves as an icon for women's rights in the East, having been martyred for her beliefs in women's rights, just as the West was securing our right to vote. And then people often ask what it means for the Tahirih Justice Center to be Baha'i inspired. So I think it's important for us to share a little bit about that. Essentially, it means that we carry some of the core values of the Baha'i faith through our work. So an example of that is our belief in the oneness of all humankind, and that the welfare of each of us is inextricably bound to the welfare of all of us. It's also seen in our belief that decisions are made better by consultation and harnessing collective wisdom, and in our nonpartisan approach to the policy advocacy work that we do. Being Baha'i inspired does not mean, however, that anyone on staff is required to practice the religion, although we do have a significant population of our staff who are Baha'i and have their own caucus within Tahirih. It also doesn't mean that any of our clients are required to practice the religion or that any of our programs include any mandatory religious elements to them. Next slide.
So thank you, Morgan. Now that you shared a little bit about who we are, how you say your name, our name, let me tell you a little bit about the work that we do at Tahirih. And in addition to being a fellow LAV grantee with all of you, we recently have become TA providers as well. And we are really excited to start this work with you to talk about trauma-informed lawyering. We have 25 years as a Baha'i-inspired organization, primarily in working with immigrant survivors of gender-based violence. We have been doing this across the country through 5 local offices located in Baltimore, Maryland, Falls Church, Virginia, Atlanta, Georgia, Houston, Texas, which is where I'm calling from, and from our San Francisco Bay Area in San Bruno, where Morgan Weibel is located. It is our mission to serve immigrant survivors of gender-based violence, and that is the only scope of work that we do. We believe that the client should lead the direction of the work that we do together. We provide trauma-informed, holistic, legal, and social services to help clients achieve the goals that they seek out for themselves within the confines of our immigration work that we offer them. We have a 3-pronged approach that ensures that immigrant survivors of violence can live in safety and dignity. Basically, our direct services informs the training and education that we offer to partners and to others in the community. And it also informs the policy and advocacy work that we do that helps us create better laws, better systems, ecosystems for not only the clients that we serve, but the many clients that we may not ever see. The types of cases that we primarily focus on, as I said, it's immigration work. And I know Leslie and NEWAP talked very much about the different eligibility requirements about many of these reliefs that we seek. But I did want to show you that what we focus, the majority of our work is asylum, gender-based asylum, U visas. That makes 70% or more of our casework, as does VAWA self-petitions, really focusing not only on the gender-based violence persecution, but also, those who have experienced domestic violence, sexual assault, dating violence, and stalking, which is the core work of our LAV grant. Their impact and the work that we do as an organization, it's really outstanding. I'm so proud to work with the colleagues that I have and the work that they do each and every single day. Just in 2022 alone, we served nearly 2,500 individuals with direct full representation or brief advice and counsel. And as you know how long many of these cases take and what is involved in working with each of these survivors, especially as we're working on very difficult, complex cases, I am just thrilled that we are able to do this in our 5 geographic areas to expand that reach to all of those who need that. The importance of having an immigration attorney is so important. I know many of you actually do this work, but the statistics show us that the odds of winning some of this relief, a very complex area of law, dramatically improves when you do have an attorney, especially if we're talking about asylum cases. The percentage of individuals that are able to succeed when they proceed on their own is only about 15%. 46% if they're represented by counsel, and we understand that that's a big thing, but when we are dealing with the complex issues of those individuals who have been impacted by trauma, it is so important to have that expertise, and through the work that we do together and collectively with our social services, we are able to increase those numbers to 96% success rate.
All right.
So, go ahead.
We're going to start off by defining trauma. If you'd go on to the next slide, please, Mary Carmen. All right. So, what do we mean when we use the term trauma? In simple terms, what we're looking for are these 3 E's in trauma: the event, the experience, and the effects. So trauma results from an event or the direct experiences, witnessing or learning of an event that involves actual or feared death, serious physical or emotional injury, or threat of injury. And when we talk about the experience, basically what we're saying is a response to the event that involves intense fear, helplessness, or horror. And when we look to the effects of that experience on a person's functioning, it's critical to remember that trauma is contextual. So what's traumatic for one person may not be for another. There's also different forms of trauma that are typically broken up into common terms as big T trauma and little t trauma. So big T trauma is a significant event like surviving a natural disaster or a single incident of trauma like an attack. And then there is what's referred to as the small t trauma, which isn't actually the result of one singular event, but instead more of a prolonged exposure to stressors like surviving a chaotic or stressful childhood, or constantly being exposed to racial oppression and discrimination. So it's not necessarily one big event that results in the little t trauma, but a series of smaller interactions and repetitive stressors that can lead to the same or even more intense trauma impacts than a large event. And I think it's really important that we keep that in mind as we talk about trauma, because that's where many of our traumas fall, and that's where many of the trauma that our clients face falls as well. I think we could argue pretty reasonably that if you're alive today, you're currently living through that little t stressors of the COVID-19 pandemic. And so I think, we likewise are seeing a lot of the impacts of that trauma in the little t category instead of that big T. The other thing to keep in mind is that, our clients, many of them have complex trauma histories and have experienced trauma over and over again. And the systems within which we operate can be really traumatic to engage in as well. We're operating within imperfect systems and unjust systems. And so that can also take its toll as well. Next slide.
As Morgan said, the clients, when they come to us and by the time that they're working with us or seeking our services, they've experienced probably numbers of big T, little t trauma. And it's important that we are familiar with like some of the things that they might have experienced, and that we already know if we're working as an organization that provides services to those that are impacted by domestic violence, sexual assault, that in itself is a trauma. And if we're focusing exclusively with this client population, that they are all already exhibiting or at least coping with a trauma that is big T trauma. And of course, if you're talking about immigrant survivors, then you also need to talk about, like, if they're immigrants, where did they leave and what happened? What were their conditions of their departure? Did they leave a place where there was a war, where there was occupation, political upheaval? Did they suffer losses? Did they have family members who were detained? Were they detained? Was there torture? Were individuals murdered? So that's other really big T trauma as well that they might be experiencing. Did they evacuate? And there's trauma in evacuation. I know that for me, I still very vividly recall those images of the Kabul airport as individuals were seeking to evacuate, and those images show, the possible trauma that individuals that survived that could have gone through and expect to have effects from. Leaving a home country where you leave everybody and everything that you know in itself can be incredibly traumatic. Separating from family and not knowing when and if you will see them again is a deep impact, and definitely something that is tremendously traumatic. Leaving your home, your belongings, and of course the trauma, the journey itself, the migration journey. We learn of stories of what happens along that migration journey that sometimes compounds and becomes even greater than the trauma that they might be fleeing. So there's many other things that the clients that, by the time they come and see us, right? And there might be additional trauma triggers, a contested custody, child welfare being somebody that's involved in their lives, homelessness, poverty, all of those are sometimes things that our clients are not only experiencing, but we might be seeing the effects of what that trauma is. So I want to ask you, if you can, on the chat, I know given the fact of the work that you do, that you've worked with individuals that have experienced trauma, and I'd love to learn from you, what are the effects that you see in the individuals that you serve? How does it manifest? And if we could just do a chat swarm with those effects that you have seen, that would be lovely. Hypervigilance, yes. All of the memory issues, lack of trust. Anger is one that sometimes takes us aback a little bit. Self-blame, very, very good. I think, Morgan, over to you.
Thank you. So many of you shared some of the effects of trauma that we've got listed here on this slide. And so thank you. That's a wealth of knowledge that you all have and experience. And, why is it important for us as legal advocates to even be aware of and able to identify these effects of trauma? Well, it's because if we don't, they can easily be mistaken for something else. And I'm going to share a story with you as from the outset of my career. Years ago, when I was working as a paralegal at a private law firm representing asylum seekers, this was way before I had ever, joined a nonprofit and received any sort of training or education on trauma and the results and the impacts of trauma. I was working with a client that I was really convinced was lying to me, because his story was always in a very non-linear fashion when we talked about it. He didn't show emotion when he talked about the things that in my mind were really emotional issues. And it wasn't until one day that I asked him to just go next door to the pharmacy to take passport style photographs. Those of you that do immigration work know that they're almost required in all of our applications. I gave him really simple instructions. You walk out, you turn left, go into the next door. It was about 30 minutes later, he called me from halfway across the city and was like, I'm lost. I can't find the location. And a light bulb went off for me. And I realized something else was going on. So I consulted with the attorney on the case, and we sent him to get a psychological evaluation. And sure enough, he was severely experiencing the impact of post-traumatic stress disorder. And so our goal today is to empower you with the info that you need so that you don't ever do that to a client. Like, no client should come into our offices and be disbelieved, first of all. But secondly, the fact that we know we're working with populations that are going to be traumatized, it's not an if, it's a when kind of question. We want to make sure that you're able to know the signs of trauma and leverage the trauma-informed tools that we'll go through so that you can keep an open mind throughout the approach, so that you can, meet your clients with compassion rather than judgment. And that can make all the difference in providing care and support to trauma survivors.
Thank you, Morgan. I think, one of the things as well from my experience is, when you are working with somebody that has these effects, it's just understanding that these are coping mechanisms that have allowed them to survive some really traumatic events and difficult situations, because sometimes not understanding what that is, like you said, could be not only like thinking that maybe it's something that you are doing, or especially when the reaction is distrust, and not just distrust of systems, but their lawyer, or anger towards the person that is trying to help. It could be very disorienting for somebody that is providing services. So definitely important to see that the effects are a coping mechanism and not some other type of deficiency that's happening in that relationship.
Absolutely. So let's go through kind of some steps and things that you might do when responding to a client in distress. And I'm going to walk us through another example of one of my experiences. Fortunately, this was years later, once I'd had trauma training and I was able to identify the signs. I was a staff attorney in our DC office and representing a survivor of domestic violence. And I was meeting with this client for the first time in my office. So I'm the lawyer seated at my desk. The client comes into our meeting. And I noticed as we were walking towards the office that sweat was pooling on her head, that she was looking really kind of distressed. By the time we got into the office and she sat down, she was literally gasping for breaths, for air. And I realized she's in the middle of a panic attack right now. And so I had to employ a lot of these techniques in the moment to help her ground. And the first thing I did was make sure that I could set myself calmly, right? Like, just take a beat and a couple of seconds to make sure I was in a calm and stable place so that the next things that came out of my mouth could be calm and slow and sensitive for her. And fortunately, I had on my desk one of those little stress balls, those things that you can kind of play with and push in, and they kind of are malleable. And so I calmly asked her if she felt comfortable, if she could pick up the stress ball, and asked her to just start squeezing it and tell me what she was feeling as she was squeezing it. And as she did this, I watched her, squeeze the stress ball. She started kind of describing it. It feels kind of soft. It's a little bit squishy. I could visibly see her anxiety dissipating and kind of lessening. And so, that's one of the tactics that we'll talk about throughout today is grounding work, right? Having someone talk through to you just what it feels like to place their hands on the desk. What does it feel like to put your feet on the ground right now? Takes them from a place that their memory and mind has taken them back into kind of maybe a flashback or a trauma response, and brings them back into the here and now. It literally grounds them in the space and time that you're in with them. And so that can be an incredible tool for people that are in crisis in the moment. but also providing that sense of calmness and stability in how you respond is what makes space and room for the client to really feel their emotions. And it sends them an implicit message that what they're experiencing is tolerable to you, that you can take it, you can have them feel that in front of you, and that it's okay. And so after she, described some of those things, we sat together in silence for a bit, just so that she had some room and space to kind of process what was happening, and so that she knew that I was okay with what was happening. So much of the dynamics of DV, domestic violence, and the other kind of power and control situations that we see, sexual assault, whatnot, it puts survivors in scenarios where they're gaslit or they're made to feel like their emotions are totally unwarranted. So just making the space for them and accepting their emotions can be a huge step in breaking that cycle of trauma that they've been experiencing. I mean, imagine if I had instead responded to her panic attack by saying something like, okay, let's get your paperwork. And I just started peppering her with questions and going about my routine work. The overwhelm she was feeling would have only multiplied. And it was only in that silence that she was able to open up to me and start to share how scary it was for her to meet with attorneys and how nervous she was about her case. And then that gave me the opening and the opportunity to validate and paraphrase. And so I said something like, it sounds like you're feeling pretty overwhelmed, and that is totally normal and common. It's almost even an expected response to what you're going through. A lot of my clients feel like the sense of overwhelm when we sit down to discuss their case. And then we moved into talking about some of the things that we could do together to make it more comfortable and as easy as possible. We talked about, some of the tactics or tools that we would do together. And then she asked for a glass of water, which I got for her. So that was a great place where we could develop rapport and I could help meet her needs. And then after that, we identified a couple of other things. I said, look, it's not going to go away in one day, right? It's more than likely that, you're going to continue to feel like this for a while. So let's talk about what are some of the things that you've done in the past when you felt stressed. And I think it's really important to recognize and help trauma survivors see, if they don't automatically see it in that moment, that they hold the tools necessary for survivorship. I mean, this was a woman who had experienced years and years of domestic violence. And over that entire time, she'd employed a whole ton of coping mechanisms, like Mari Carmen mentioned before, to take care of herself, right? And just giving her that space and time to reflect on those things with some guided questions got us to kind of what the next steps were going to be as we worked together on her immigration legal case. So I said, what have you done in the past that works for you? And she shared that she liked to pray. In the past, I've had other clients that have shared things like, I like to listen to music, or I go for walks, or I like reading or creating art or taking deep breaths. If you're with a client and you ask them, what are some of the coping mechanisms you've used, or what are some of the things you've done in the past, and they draw a blank and they can't think of anything, you can offer some of the examples of things that either work for you in self-care or that other clients have shared with you to see, does any of that sound like it might work for you? Are you resonating with any of these examples? And then we talked about other things in her life that helped her cope. And I said, is there someone else that you rely on or depend on? And she shared that she didn't have anyone, which is, not all that uncommon in DV scenarios where a survivor has been really isolated. But had she said, it's my mom or it's my sister, then I would have encouraged her to seek out that person, even if it meant remotely, like give them a phone call today, reach out, connect with your people and your networks. So that got us through kind of like the immediate issue, right, of the panic attack. But, we had talked about this was likely going to be something that was going to be a stressor for her as she worked with me throughout the case. And so, we needed to think through what are some of the things that could help reduce her anxiety as she approached her legal case. And so what we settled on was a lot of the anxiety was coming from not knowing exactly what to expect, which is, totally understandable, right? And so what we did was at the end of every one of our meetings, we took 15 minutes to go over our plans for the next meeting. So she knew what topics we would be talking about. I made a bullet pointed list of them and printed it out so she could take it home with her. And then sometimes she'd look at that list later on in the week and call me up and be like, I see this second bullet point, but I don't know what it means. I can't remember what we were going to talk about. Can you tell me more about that? And I'd share with her, you know, what I remembered that we were planning to talk about there. And then at the beginning of the next visit, we'd sit there, we'd pull out the list and look at it together. And I would say, what order do you want to do this in? Like, which, you know, these are the ones that we agreed we're going to be working on. And there were times where she said, you know, number 2 feels like too much. And so we'd push it off to the next meeting. And then there were times where it would be like, you know, number 3 feels like too much. And it was something we had pushed off enough that I knew we needed to be able to move forward on it, because there are pieces of immigration cases that are time sensitive and, you know, require getting to in a certain order. And so in those instances, I would say, I think we do need to get to this. Here's why we need to get to it, why it's useful for the rest of your case, and what can we do together to plan around it that could make it a little bit easier. In this case, I was really lucky that she was interested in going to therapy, and so I was able to provide her with referrals to another service provider. And so we'd structure those meetings like the ones with the difficult topics so that she'd meet with her therapist immediately thereafter. There's a whole bunch of inventive things that you can do to work with clients to be able to address the traumatic pieces of their case that doesn't require the traditional question and answer format that attorneys are used to doing in order to get what they need for like a declaration in an immigration case. Leslie mentioned in the last training that NWAP has some great tools on trauma-informed lawyering questions. So I encourage you all to access those. But simple things like thinking about whether or not you can get informed consents for both you and a therapist that the client is working with so that the client can tell the therapist the trauma story. You can include it in your draft of the declaration. And of course, as immigration lawyers, we know that we need to review everything with our client before it's submitted. So eventually you'll be going through that information with her to confirm that it's all accurate, but you don't have to walk her through the questioning the first time. That could be something that she gives to a therapist that you receive there and include in the declaration. I've had other clients that felt more comfortable drafting out the notes themselves and handing that to me, and then I would read those and incorporate them so they didn't have to talk about them in the meetings. I've had clients draw images or pictures of things as descriptors. So think creatively about the things that you can employ. And I think this is a great moment. I know that we've got a lot of seasoned practitioners on the webinar as well. And so I'd love to invite you to share in the chat some other strategies that you've used over the years to respond to clients in distress. What are some of the things that you've worked out with clients to help support them? What are some of the resiliency strategies that you've used? If you could just share them in the chat, that would be fantastic.
Thank you, Morgan. I think this is like a really brilliant example of how you can be therapeutic without being a therapist. Just listening to some of the things that you did, you know, to help your client through a really difficult situation shows how we can actually incorporate some actual tools in the process of the work that we do. And I would love to see, you know, I know we have a little bit of time. It is the last presentation of the day, but if it's easier to unmute yourself and share something that you've used that worked, that would also be really great.
Mari Carmen, they're starting to come in. So yeah, offering different
great.
options for collecting information, just listening and letting them ramble if needed. I learned the practice of looking at each corner of the room saying, I am safe here. Yeah, that is a great piece. We're going to talk about safety later on, but that can be great to just remind clients and ourselves, right? That is something, because we have our own trauma triggers and that can happen in client interactions. Yeah, speaking calmly, acknowledging feelings. These are all great tools. Mari Carmen, if you would switch to the next slide.
Sure.
Okay, so now we're going to take a moment to talk a little bit about trauma and memory. So you remember the client story that I shared at the beginning of this that I worked with, who I thought was lying because he didn't show emotion when we talked about his past traumas. That was an example of him checking out or dissociating. As Mari Carmen mentioned, that was his coping mechanism. And, one of the things that was made me question at the time was that he had these really specific details about certain things in his experience and past, but then he couldn't provide much detail at all about other things. And so for me initially, because I didn't have any of the training in trauma, I thought, oh, that's an indicator that he's making this up. But the reality is that was one of the surest indicators that he had suffered trauma, because that's exactly the way that trauma impacts our memory. So we know that traumatic stress rewires it. It changes both our neurochemical systems and our specific brain regions. And because a traumatic event just totally defies logical sense, it can be really difficult for our human minds to compartmentalize and organize the things that we normally would do throughout the day. So in turn, it makes it harder for us to recall or pull that information out when we're asked about the event later on in life. The other thing to keep in mind is that when people feel really threatened, they experience a significant narrowing of consciousness. So trauma survivors are much more likely then to remember certain specific parts of the event that were really central to their consciousness at the time that the trauma occurred, and less likely to remember other kind of peripheral details. So the things that we typically do to check veracity of a story, like ask for minute details, may simply be totally inaccessible to trauma survivors. That's why a trauma survivor might be able to recall like the very specific details about a weapon, because the threat of that weapon, or that weapon represented at the moment, made it the central focus of their consciousness at the time of the attack. But at the same time, the trauma survivor can't recall all the other details, like what the perpetrator looked like or the car that the perpetrator may have driven up in. And so what we have is this clear mismatch between what law enforcement needs in an investigation and what legal systems ask of survivors to describe in order to check if it's truthful or not, and what survivors of trauma's memory can actually recall and provide. And unfortunately, neurobiology also tells us that often the most peripheral thing to a traumatic event for the human mind is the date and sequence of events. And that's really unfortunate, because for legal matters, that's often the most important thing, right? You have to put the date and the sequence of events in order for the case that you're presenting. And so our entire legal system and process is based on order and logic and chronology, and it sets trauma survivors up for failure from the get-go, because the human mind's just not going to let them recall memories in that way. So I will say that on a practical note, this is a perfect place to employ expert witnesses in legal cases. If you are seeing the signs of trauma come up as you're working with a survivor and they're having some memory issues, don't be afraid to bring in an expert witness to help translate that kind of mind recall issue for the court or the judge, so that they can understand what it is that your client is really facing. Mari Carmen, you wanted to go to the next slide?
Sure. I think at this point, we're going to be shifting more into a compassion exercise. And what we're going to do to facilitate this, I know, Morgan, you're going to drop a link, there it is, to a Jamboard. And what we will invite you to do is to think of a time in your childhood or when you were younger, when you were facing a challenge, something that was very difficult for you to overcome. And, what you would tell that younger version of yourself at that moment? So I know that this might be, incredibly personal. So hopefully being able to include that in the Jamboard, think about the things that you would say to your younger self in those situations. It might have been, moving to a new city, starting a new school where you knew no one, losing somebody that was very dear or close to you. Those are just some of the examples of things that maybe folks have experienced or experienced as they were growing up. And we will be taking a few minutes to let you write what you would say to yourself as a younger person.
Great. I can see some folks already joining the Jamboard. For those of you that may be less familiar with Jamboards, once you click on the link, you should see a big screen, and on the left-hand side, there's a little icon called a sticky note. And if you click on that, you can enter your comment. So please keep adding to that Jamboard. Oh no, John and Kelsey, I see you. I'm sorry, there's too many people. You guys overwhelmed the Jamboard. Let me see if we can log out, and maybe that can let some others in. What I will also do for those that aren't able to access it is just start reading a couple of the compassionate statements. So this is not forever. Breathe. Everything will work out. You can get through this. You are stronger than you think. Everything is temporary. Be kind to yourself. There is no hurry. You are loved. You are not responsible for everything. You are not in charge of keeping everyone together. Seeing some themes here pulling through. It's okay to be angry too. Yes. It sucks now, but it won't be forever. Breathe, just breathe. Let's see, the worst is over. It will only get better from here. It was not your fault. You will be okay.
Thank you for sharing that, Morgan. I don't know if people are still writing, but one of the things that I think is really important, we've covered a lot, and even, us by asking you to recall something that was a challenge, something that we do with clients when we're talking about things that are really deep or we've been sitting for a long time is take a quick little break, stretch, breathe. So we're going to incorporate this as a part of our training so that you get a quick bio break or just a stretch and like recalibrate again and soak in the work that we've done. So let's take 5 minutes and come back and join us.
So folks on the West Coast, that'll be back at 1 o'clock, and folks on the East Coast, that would be back at 3 o'clock.
All right, I think my clock says it's 3 on the clock, at least here in Central. How about you, Morgan?
Yeah.
We're good.
Yeah.
Awesome. So let's start talking a little bit about the trauma-informed approach. And I'm going to start with talking just with some assumptions of what the trauma approach is, or that we should be starting with when we work with somebody and employ what we would call a trauma-informed approach. And we call it the 4 R's: realize, recognize, respond, and resist. Realize, because we must realize and understand that trauma not only is it widespread and that, people just by existing often are already experiencing some form of trauma, but also how widespread and how much it implicates, other aspects of our lives. So knowing how it affects people, knowing and understanding that these are coping mechanisms, that is realizing, right, what trauma is and that how it affects people. Recognizing those signs of trauma, I think just from this exercise that we've done already, and the effects that not only Morgan shared and the effects that each of you shared, it is really obvious that many of you have already experienced and worked and see what those manifestations of trauma is. And then the important part is definitely to respond to these situations that we are going to be working on, applying techniques, like Morgan mentioned earlier, things that you've done before to really like limit and lessen, the impact of that trauma so that we can get to do the work that we need to, and hopefully not re-traumatize the individual through the work that we are doing. So it must assume that these 4 different assumptions are present for us to be able to effectively say that we are employing a trauma-informed approach to our lawyering. There are 6 principles. This is not something that obviously came to us as lawyers. I mean, we have adopted this because it's important. It was actually created, it was a framework that was created by SAMHSA, which I need to look up what exactly that is. It's the Substance Abuse and Mental Health Services Administration created this framework because they realized that many of the things that they were seeing in working and providing services to those who were impacted by substance abuse and others were really many times responding to trauma. And they wanted to create a framework and not a to-do list because they wanted to be able to adapt it to many different systems, whether it was the child welfare system, those impacted by criminal justice, and similarly, as lawyers who work with individuals who are traumatized, this specifically for those that work in the area of domestic violence, sexual assault, it is incredibly important that we employ these tools and adapt these principles to the work that we do with our clients. And we're going to break down each one of these principles and like really dive into it. But safety is one of the most important things in so many ways in the work that we do. Trustworthiness and transparency, that important of having peer support. We're going to talk about that. And maybe even as we speak about it, it will resonate with some of the things and experiences that you've had in your work. Collaboration and mutuality, empowerment, the voice that you use. I know even listening to Morgan speak today was so important, but the voice of the client needs to be heard. And, what they want is going to be important in not only helping them overcome what they've endured. Cultural, historical, and gender issues. We'll also just dive into each one of those. So safety. I know many of us are very familiar with like safety planning, what we do. We're looking at every aspect of safety when they're with us, when they go home, if they're still living with an abuser. But it's really, really important that we start taking ample steps to not only promote that physical safety that we know we're always looking for as attorneys that may do protective orders and other work like that, but also that psychological safety. It is important that we understand, how they're reaching us, how they're accessing our services. Many times individuals will call to do an appointment, or do we call back? So really trying to ascertain from the clients if they're in a safe place to speak freely, right? I know with some of our immigrant clients that we've been working with, especially just recently with the individuals that evacuated from Afghanistan, many times they were in bases, Air Force bases and other places where they had no privacy to speak about the issues that were happening. So really asking them about, is it safe for you to speak right now? maybe they're living still with their abuser. And, you know, if it's not safe, then consider delaying that conversation. Is it safe to call them at the phone number? I know for us, when we are scheduling a callback, it's really important to also let them know, for a part of that emotional safety is, you know, what we're going to be talking about, so that they know where to secure a space. And if it's going to be appropriate, maybe the kids are going to be with them, maybe they're going to be going into class, so that they can emotionally also prepare for the conversations that we may need to be having at any given time, so that it's emotionally safe for them to share information in that context and not feel that they need to hold back or limit, or and then go into an important meeting, or, you know, go back to class, as we've had situations like that in the past happen. Knowing and explaining the use of technology, especially if you're working with somebody that maybe does not have a full understanding of technology use, is going to be incredibly important as well. Can we leave them messages? Who owns the phone line? Who else has access to it? What would be the impact of knowing that they're receiving legal services in connection with a domestic violence or sexual assault issue? Those are incredibly important conversations to have. And sometimes the survivor may not know that there's an option, or that you might actually be able to accommodate to make it happen for them as well. And one of the most important things is really to understand that safety has to be defined by the client. If you notice or sense that something is just not landing right, that there's some kind of hesitation, do we really need to do this right now? Can I call you back later? Like, really take those cues and then follow up, because definitely we want to make sure that we are defining safety the way the client needs to feel safe.
That's right, Mary Carmen. There's no one size fits all for any of this stuff. And that is why it is so important that our work is client directed and client driven. So let's look a little bit at trustworthiness and transparency, because decisions are made with transparency and with the goal of building and maintaining trust, or at least that's what we should be doing through our work with survivors. And, you know, this starts at introducing yourself to the client at the very outset of your representation or work with the individual. It's letting them know who you are, and sometimes even way more importantly, who you are not. And so one of the first conversations I'm having with any survivor that I sit down with is, I'm not part of immigration's customs enforcement. I am not part of the US government, and I am not sharing any of the information that you provide to me with any of those entities without your explicit written consent. So clarity also on what you will do for clients. We at the Tahirih Justice Center have sample client engagement letters that have very clear documentation of, like, these are the types or forms of relief that we can work on. We check that box with the client so that it's clear this is what we'll be representing you on and what we won't be representing you on at this time. And we're happy to provide TA to others out there as you're working through your materials. It's super important to be honest about the limits of your own knowledge as well. It's far better to admit that you don't know the answer to something and offer to find it for the client than to make it up as you go. That's probably the number one way that we as attorneys can lose trust with our clients. And never, ever, under any circumstances, should we be making any sort of guarantees about outcomes. And that's because once we file that case, once that matter is in the hands of the judge or immigration services or the family law court or whatnot, we have no control over what they do with it. And it doesn't mean that, you know, we need to go about scaring clients and making them feel like they have no legal case, but it does mean that we need to be realistic about setting their expectations and saying things like, you know, in my legal opinion, your case has merit, or it's strong. That's why we're representing you. But once we hand it over, we can't control what happens with it to a judge or a court. And so we can't tell you a likelihood of success. And I will say this is one of the most difficult areas of conversation with clients, because they always want to know the percentage of success or how likely it is the outcome of their case. And we just cannot give that to them, because it's not honest to be able to tell them that. It's, we simply don't know, particularly in the immigration context, where even if you know you have the best judge on the court that you're before, that case could get transferred to another judge and end up on another docket. And so helping to set realistic expectations is making sure that you don't, promise anything that you can't follow through on. And then I think the last point on this slide goes back to that mantra that we talked about before, which is, we don't want to re-traumatize clients. Our goal here is to do no harm, right? And trauma survivors are already confronting all sorts of challenges. They don't need any unnecessarily added onto their plate. So this is a place where, as an organization, you should be spending time thinking about your processes and your policies and identifying, are they absolutely necessary? We are happy to provide technical assistance on that and looking at policies and programs. And then also you can bring this down to the advocate level as well. Like, as an attorney, you should be thinking through all of the steps that you typically walk through in your normal routine with a client and asking yourself, do I really need to ask that question? Do I need that detail or not in order to construct the legal case? And if I need it, what can I do to kind of soften the blow of it, or to make it a little bit more approachable for the client? What are some of the trauma-informed approaches that I can employ if I know I need to go to this area of traumatic history with the client? So I'm going to ask now for people to share again in the chat examples of things that you're regularly doing with clients that helps demonstrate your trustworthiness and transparency to them. So it could be something big or small. It could be, I always hold my appointments with clients. I don't cancel them. Or, it could be, if I tell them I'm going to call, I call, or if I don't, I, explain I was sick that day. I'm sorry that I wasn't able to call you by a certain time. What are some of the things that you're doing to help kind of stress that trustworthiness with your clients? Yeah, asking for safe times to contact them. Great. Yeah, asking if they're available, asking for consent, right, throughout the process. Are you comfortable with me calling you? Are you comfortable with me calling you at this time? Explain that you're not going to force them or make them to do anything. Help manage their expectations. Yeah, listen to the full story without interruption. Okay. Explain confidentiality and the exceptions. Yeah, giving them the information that they need to be able to make decisions on the case. Being honest about limitations. Yep. I mean, that at the core of building trust is setting and maintaining healthy boundaries, right? And so the more that we can do that and model it with clients, the more trustworthy we become. Returning phone calls. Yeah. Listening, managing expectations. Great. Thank you guys. Those are all great examples.
Another of the principles is peer support and mutual self-help. Never underestimate the importance of having peers be available to support survivors through this journey. I know I had a case that I worked with where I was working with an individual who left a very abusive home environment. She came from a different country, and we got her into a shelter very safely. She was getting all kinds of support at the shelter. And ultimately, because it was such a culture change for this individual, like adjusting to like different eating styles, like not hearing the language that she was accustomed to on a regular basis, she was really deteriorating. And, it was really great that I was able to speak to the individuals and the advocates at the shelter, because we found somebody that might be a better fit, and they did not have a residential place for the individual to work at, but we were able to secure a connection with somebody that like understood her situation took her out to eat, bought her some food that she would feel comfortable with eating, and then just had that ability to connect with somebody that understood what she was experiencing in that moment. So that dramatically changed, like, not only the trajectory of how the client engaged in services, but that is just one example of where we were able to really have that inclusion of other family members. Many times when we're working with survivors who are immigrants as well, that peer support might be completely gone. They might have been depending only on that abuser for a lot of that connection, or even the abuser's family. So really understanding that and having that validation, encouraging when necessary, to seek and maintain those relationships that really fulfill the individual, can really assist in that recovery process, and also in the engaging in services with you.
That's right, Mary Carmen. And that's why a lot of organizations provide like mutual support groups, right? For clients to feel and build that community. And if your organization isn't able to provide that, then figure out who in your community does, because there's a lot of great agencies out there that are providing it. And we'd be happy to connect you with agencies that we're aware of. So the next thing that we're going to go over is collaboration and mutuality. And the reason we're looking at this is because we know that healing happens in relationships, in the meaningful sharing of power and decision making. And so as the attorney or as the advocate on the case, you hold a lot of power. And it's important that we recognize the power and the privilege that we hold. We've got legal knowledge, we have cultural knowledge, and understand like what you need to wear to court and what the decorum is in a courtroom. We have positional power, being an attorney that, can bring a lot to the meeting for clients as they meet with us. And we have language access a lot of times. English may be our first language, or at least a language that we're very comfortable conversing in, and in highly technical terms in the court. And so it's important that we recognize all of those powers that we hold, but it's also equally important that we recognize the power that our clients hold. They have a whole bunch of powers in their toolbox. They've got cultural knowledge. They have knowledge of their own story and lived experience, and they have the immense power to survive all of their past traumas that they've been through, right? They've got all those coping mechanisms that we talked about earlier in the presentation. And so basically our goal in this collaboration and mutuality should be to look for ways to shift power away from the systems that we're operating within and from our positions of privilege across the table to the survivors that we're sitting alongside. And so the question is, how do we do that? Well, we give choice to clients, right? As often as we're able to do that, we provide them with full and clear information so that they can make informed decisions. And we work on their timeline and at their pace, even when that means that we have to approach things in a less conventional way, or not in the same way that we've always done things before. And so really, I think the point here is to think about, we fit the approach to the person rather than trying to fit the person into our approach. You've got to pivot and innovate together collaboratively, finding what fits right. And it's never going to be a one size fits all. Just because it works with one client doesn't mean it's going to work with the next survivor that you're meeting with. Next slide, Marie Carmen.
Sure. The next principle is empowerment, voice, and choice. And this is like so important that we not make assumptions about what the survivor wants. We know what, we may need to obtain, or what we can obtain in a court proceeding or in a legal outcome that they might have been seeking help from us, but don't assume that that is what they necessarily want. Obviously, it's very important that you offer options and that you ask. I will strongly urge about the options part of it, especially because, and if we're speaking with somebody, and this can happen in any context, not just in somebody who may be an immigrant into our country, but people may not know what options may be available to them. You know, I remember giving like legal options conversations and charlas where I would talk to survivors who did not think they had the option of leaving their abuser. They thought that would be abandono de hogar. And so like really being able to, you know, share what options they really truly have really allowed them to start exploring what it is that they want. So make sure that you offer options and then really revisit each time to see if that's still what they want. To give them voice, explain the purpose of the meeting. Why are you meeting today? What is it that you need to accomplish in this meeting? It's so important. Talking back about what, you know, Morgan, you shared, right, is so important that they feel empowered, that they understand the process, you know, that we thank them for like keeping their side of what they were supposed to do, for sharing their story. It's important that we know if they're comfortable with the goals of their representation that we're offering. You know, I know, for instance, oh, hi. It's so important that we know what they want. And another example, you know, just when somebody in divorce cases, right, usually the abuser will be the one that initiates. It's been my experience, they initiate the divorce proceeding. And so we're in a defensive posture. And sometimes it would be that we file a counter petition for divorce because we want to ask for the same things, but really find out what the survivor wants. Because like in some instances, they're like, I want to fight and defend the divorce, but I personally do not want to be the one that's filing a divorce. And like really understanding those nuances could be cultural, or it could be something else that's happening. And it's really important to let them feel like they have a voice in how we proceed after all those you know, options have been explored. Evaluate alternatives that give to the same goal that maybe the client might be wanting to reach, or where you can protect them. If there is trauma disclosed, and this is again the same, you know, that Morgan has shared earlier with us, offer some of those resiliency cues. Like sometimes as you're getting really deep into the work that you're doing, that trauma and trauma responses will resurface. So do that. Like what happened? How were you supported in the past? You know, reminding them, you know, how they've made choices and survived throughout, and like really getting them back to empowering that they have some of those tools, and then encouraging them to access those, whether it's reading a book or calling their parent or their sibling, and, you know, the things that will help them be feeling less disempowered by a trigger or something that happened.
All right. And a trauma-informed approach also requires us to take into consideration cultural, historical, and gender issues, right? So, you know, what we want to be offering are culturally responsive services, recognizing and leveraging the healing value of traditional cultural connections and addressing that historical trauma. And in order to do that, I think at the core of all of this is something that we talk about a lot at the Tahirih Justice Center as cultural humility. Can I get like a thumbs up from folks? Feel free to either put it in the chat or just, you know, raise your thumb on the screen. If you're familiar with the term cultural humility, is this something that is new, or we have some familiarity with it? Okay, let me just kind of broad brush strokes explain kind of some of the concept of it, which is, you know, for years we talked about becoming culturally competent, right? This idea that, you know, you could learn or understand someone else's culture that wasn't your own to the point that you could be competent in it and fluidly, you know, work within it. And cultural humility kind of flips the whole thing on its head, this concept, and says, instead of trying to like learn a checklist of somebody else's cultural tendencies, because we know that even within cultures, individuals have different interpretations and applications of that. Cultural humility asks us to look at ourselves and say, okay, what kind of like biases am I bringing into the room? What are some of the assumptions that I make based on my own background, my own experiences, and how do I check those or set them aside so that they don't influence the way that I approach or work with this client? So, typically if you're working from a cultural humility standpoint, you're going to focus on the individual. You're going to allow the individual to explore their feelings, their beliefs, their behaviors. You're going to be open-minded. Really what you're focusing on doing is being a good listener. And when you don't know, ask questions. So you really want to avoid making assumptions, be mindful and respectful. So don't assume that people from a certain country have a certain religion, or that people have certain language capacities or capabilities, or that because somebody, explains that they went to, for example, law school, that they had the same experience that you did in going to law school, or that they covered the same materials, right? The point of this is prioritizing learning and keeping an open mind and being humble in your approach, recognizing your own biases and making sure that none of those lead you to make incorrect assumptions. And this is another place where organizational support can be really instrumental. If you build the psychological safety that you need amongst your colleagues, you can kind of call each other in and share like, hey, I think you might have made an assumption there. And your colleagues can help you kind of see some of the blind spots that you might be walking through the world with. And so this is another area where, like, if you're truly embracing kind of the approach to cultural humility and thinking about all of these different contexts, it's going to make you a much better advocate. And it's also going to make you a much better friend, family member, person out in the world. So let's go to the next slide.
Just paying back on what you shared, Morgan, I think, definitely avail yourself of resources. I think it's important. And I know you talked in the past about how it's important to talk and like maybe visit with experts, to share their expertise when talking about trauma. I think it's equally as important sometimes when we are talking with somebody you're not familiar with their culture as much. And, it's been really important in some of my practice to work with those individuals who are experts in certain communities or who have worked with specific client populations, so that I can ask better questions, right? So that I can be better informed, or that we can provide better services and get the information that we need. Sometimes it was really important that I had that information in advance, as I knew I was working with somebody that I had never worked with before, and I had read the initial summary of the case that I was going to be working on. So really getting that expertise and understanding some of the culture, the nuances, the areas that I need to be aware of, has been very, very helpful. Obviously, once you start working in one similar client community, then the problem would be to make these assumptions that all clients from that specific population would be the same. And then again, that piggies back on what you just shared, that don't make any assumptions. There is differences between even the same client community and how they interpret things and what they do and how they, so it's really very important that you keep an open mind and that you ask questions and just become more sensitive and aware and humble to understand those differences. There's also really important cultural issues between those low context and high context cultures. I'm Mexican. I mean, some people talk with their hands all the time. And we might be making some assumptions based on some of the things that we are seeing verbally communicated to us or not. So also really knowing facial expressions. Do we look at the gestures? Some individuals may communicate better in writing. Others, may not look at you straight in the eye, and just how to understand those differences is going to be really, really important. For instance, I know some individuals will just always defer to the lawyer and not want to take a stance, and you might misperceive it as being somebody that doesn't really stand for one thing or another, but it might just be, a cultural issue as well, that they don't want to, disagree with you. So how you approach those communications is going to be really important. Also, we need to know that some individuals like really internalize their emotions and sometimes like start experiencing also like some somatic uncomfort based on like how they are experiencing certain situations. So it's important that we are not only aware and understanding, but humble in that work that we do with individuals that may have a different culture than what we are familiar with.
Great. We also want to be keeping in mind gender-related issues, right? And, as many of us work with domestic violence survivors and sexual assault survivors, we know that, sometimes it can be just far more comfortable to sit with someone of your same sex and explain and describe what's happened to you. But for some survivors, that isn't the most comfortable place to be. And so this is another one of those moments where we really need to check our assumptions. Just because it might be more comfortable for me doesn't mean that that's going to be the case for my client. And going back to that whole trying to give choice and power over the clients wherever possible, these are great places to think organizationally, like, do we have enough staff that we could offer, clients could pick the preference of their legal team. At the Tahirih Justice Center, we partner with a lot of pro bono attorneys. And so that's one of the first questions that we're asking clients as we're taking on their case, like, what are you comfortable with as far as the makeup of your legal team? If we assign pro bono attorneys to it, are you comfortable if it's an all-male team, or would you prefer having one or two females, and get into the details on it? It's not enough to just ask that, but to then also say, okay, part of the case requires that you sit down and detail your past history and your trauma. Who would you feel most comfortable with sitting down with and explaining that whole story? Would it be a male attorney? Would it be a female attorney? Do you have any preferences there? Because you can staff cases in a way, so maybe the primary contact that's working on the declaration with the client is a female, and then it's fine that the rest of the team is male working on the case, or vice versa. But that's something that's worth kind of looking at your organizational processes and who you can leverage with community supports and others to make sure that you're meeting some of those preferences so that clients can be in kind of a more comfortable space. Because we know that the dynamics of gender really do play into what people feel comfortable sharing. And discussing their story with. And it's important to also keep this in mind when you employ others to come in and assist, right? So if you're bringing in, a legal advocate or a paralegal or a social worker to support, the same thing goes there, to ask about gender preferences. And if you're using an interpreter, that's another thing to be very conscientious of. It can be extremely difficult for someone to express themselves to someone of a gender that they're uncomfortable with. In being able to detail their case. So that segues actually pretty well into the next section that we're going to go into, which is working with interpreters. And so, we tried to kind of put up on this slide some things that you want to be thinking through as you're selecting interpreters with clients. Again, one of our trauma-informed approach principles is do whatever you can not to re-traumatize the client. And so in selecting an interpreter, you can take a lot of real steps towards making sure that you're not putting the client in a position where they might be re-traumatized. So you want to first confirm the client's preferred language. Don't make any assumptions, right? Some of our clients speak 2, 3, 4 languages, which is the language that they'd feel most comfortable talking in. I just recently had an experience where, we were trying to decide if we needed to get an individual Indigenous language interpreter for the client in court. And what we realized when we talked to the client about their preference of who they wanted to interpret was that all of the trauma that had happened in their childhood had happened like in their Indigenous language. And so having to do all of those things in court was going to be more re-triggering to use the indigenous language than it was to go with Spanish for interpretation. And that is something that I probably would have never guessed. That wouldn't have been my natural assumption for what the client would have preferred. So it's really important that you stop and ask clients about that. Recognize that there's lots of variations in language and dialects. And really, this is where, consult with experts or those that really understand the dynamics of it to make sure that you're getting the right fit on the interpreter, because that in and of itself can be really traumatizing for a client to have the wrong, dialect. And it can feel really isolating again. And like, they're not being understood or seen by you. The other thing that's really important to remember is that in some of the populations that we're working with, the diaspora in the US is extremely small. So people may all know one another, and selecting an interpreter from the same community can be a really tricky thing. So you want to do your best to, make sure that you're finding an interpreter who shares their linguistic, ethnic, and gender traits with the client, if that's what they prefer, and be flexible and creative in trying to make that happen. And whenever possible, you really want to avoid using family members. I think too often, people in a pinch think like, okay, I'll just get, this family member because they were the person that approached the organization initially and said this person needed services or help. And so, I know they're comfortable with them, but there's so many dynamics that are involved in having family members interpret, particularly if it's a child interpreting for a parent who's survived trauma. The dynamics of opening up that child to the traumas that their parent has experienced. There may be so much more that the person could share with you. And in asylum cases, for example, that could be the differentiating factor of whether or not the case wins ultimately or loses. And if that client is talking through somebody that they're uncomfortable sharing some of the details of the past with, that could completely hinder your ability to prepare their legal case and present it. So you want to make sure that you're very careful around that. And then finally, just a really practical tip, you want to budget twice as much time when you're working with interpreters on any case, but when you're working with trauma survivors and interpreters, maybe 2.5 times the time, right? Because you're going to need to take pauses and you're going to need to take breaks. And it just takes twice as much time to talk through each of the questions and have those interpreted. So make sure that you're budgeting the right amount of time and that you're sharing with the client ahead of time, setting the appropriate expectations of how much time that's going to take with them.
Thank you. And I agree, Juana, it is best practice to not use family members at all. And sometimes the limit might be to leave a message if, it's been declared that it's a safe person to connect with. It may be very, very minimal. Always incredibly important that we have an interpreter that is not related or for many reasons, or somebody that is an acquaintance of that individual. Another thing that I think is really important as we work with interpreters, especially as we're doing this kind of work, which could be really intense, and like even sometimes it may trigger things on interpreters who may not be ready to do some of this work, is do some training, especially if you're working with like community partners that are doing some interpretation work for you. Make sure that you're offering training, that they know the words to use for the things that you will be discussing, because sometimes that could be very different in different circumstances. The other thing is, make sure that you are kind of listening also for the interpretation that's happening. What is the tone? What does it sound like? Is that typical? Is that the same thing that you've heard before? Like, it's really important that you continue to monitor, because sometimes there can be other dynamics that are occurring. And if you're not familiar with the language, you could totally miss that. So definitely stay engaged in those issues. I've had situations, and I think we all have as lawyers, where you do a quick question and it goes on, and it seems like the interpreter is having a whole conversation separate and aside. So those are things to be really careful about, and like really understand what is occurring in those situations. If anything is going off, like look at the cues that your client is giving you. If they're being if they're frustrated in the communication, like that is really, really important. I remember being in court. It was a very unusual language that, we couldn't find a great interpreter. And at one point, and I didn't speak the language, but I could see that my client was getting very visually upset, and she could understand enough English to understand that the translation was not happening correctly. So in that important time, especially if you're in court or if you have this opportunity, it's and you don't know who your interpreter is and if the information is correct, prepare in advance, the types of questions that you're going to be sharing with the client and the testimony that you're going to be eliciting, so that the client can alert you if things are not happening the way that they need to be happening. In that case, we had to suspend it and find a different interpreter, because it was really, I knew from the answers that I was getting that it was not what I was asking and what I had been for many, months and getting into a court setting, what we had been discussing. But definitely be very, very much attuned as to what's happening. Don't just assume that the conversation is happening the way that you think it is. So,
Mari Carmen, if I can add,
sure.
One of the things that I've kind of developed over the years is creating a signal with my client who speaks another language ahead of the interpreter meeting, so that, if that interpreter walks in and they recognize the interpreter, they're somehow known by the abuser or connected, or they're uncomfortable in any way, shape, or form, I know what signal she or he or they are going to give me, so that I can just call a quit to the meeting and say, I'm really sorry, I've had something come up. I need to, I have to go to court right now. We're going to have to cancel this and reschedule. And then it doesn't have to be any weird dynamic with the interpreter to tell them what's happened with the client, but it allows me to know that the client is uncomfortable. And I think in particular, when we're working in immigrant communities where the diaspora can be so small, it's really important to have that set up ahead of time so that they can give you that signal, or they can cough and okay, that means I'm going to just call a pause to this meeting, be able to consult, and then move on, so that they're not in an awkward position. And that allows them to kind of not have to reface the traumatization of seeing an abuser's colleague or friend in the moment.
That is so important. Thank you for sharing that. With others, it could be equally as traumatizing to have to do that and share that information. So we're going to now shift a little bit into, vicarious trauma and self-care, because we've been talking about recognizing trauma, in our clients, recognizing how it impacts, their behavior, the effects, in the work that we do. But really, this is also something that impacts us as professionals. So it's incredibly important that we are just as attuned, recognizing when we are being impacted by trauma, by the work that we do, and that we take steps to address it. I know that helping professionals develop vicarious trauma, up to 85% of the time. So this is not unusual. It's what happens when you do this work and constantly are exposed to these stories. You take them in, you incorporate them, and a couple of things can happen. There's vicarious trauma, which, we experience the trauma ourselves, right? And we might be feeling from the repeated exposure that our view of the world totally changes. I recall very vividly, being really enmeshed in a particular case where the violence was so severe, and, the client was so afraid of her abuser. And, there was some very serious threats made. And remember seeing this individual drove a tow truck, and I'm driving home, and I see a tow truck parked like a block away from my house, and like just feeling every single, like I couldn't drive anymore, like my heart started beating, like I was like, oh, this is trauma, and I'm feeling an effect of trauma, even though I haven't experienced anything directly. So that's like really important to also know when you're starting to see that. Or another thing that happens very often, if you only work on domestic violence work and sexual assault, you start seeing dynamics outside that may not be at all what it is, but you start kind of really, everything has that color to it that you're like, oh, that relationship's totally imbalanced. Like, like there might be something going on. So like those are things that you might start seeing, that it's changing your view of the world. And like maybe you'll notice that like in your colleagues as you have these conversations. Compassion fatigue sometimes gets like thrown in together with what vicarious trauma is, but it's a little bit different. It diminishes our ability to be empathetic because we keep hearing over and over these same stories that we all of a sudden no longer like have the ability to have that empathy for somebody that has suffered something very extreme. And then ultimately, and what we want to definitely avoid is like burnout, where you are just so physically and emotionally exhausted from this onslaught of just hearing the hardship stories, and so these are really important things that, we need to be assessing ourselves and how we respond to it, how we support our colleagues, how we support each other, and what, also, our organization can be doing to support avoiding some of these matters from happening.
All right, so you see on the slide a list of trauma exposure responses, and this was actually adapted from the book Trauma Stewardship by Laura Vandernoot Lipsky. And I can tell you that, in the 2 decades that I've been doing this work, I probably have experienced almost every single one of the things on this slide at one time or another. And I've seen almost every single one of these things on the slide in my colleagues and those that I'm working with side by side. So from my perspective, it's not a matter of if you have these trauma exposure responses, but when. Some of our former colleagues at Tahirih did a pretty in-depth survey of immigration attorneys across the country and asked them to self-report, symptoms of secondary post-traumatic stress disorder. And the results were astounding. The self-reported level of PTSD was higher than any of the other professions that they had looked at, like prison guards and immigration judges. So this is something that we know is going to be part of our work, and it's important that we invest time in identifying some of our resiliency strategies. And so what we're going to do right now is actually break you out into groups of 5 to talk for about 5 minutes together and share a resiliency strategy that you have used to respond to and care for your own trauma responses. So I'm going to drop that question in the chat here so that you have it as you go into your groups. And then I'm going to ask for the assistance of those at OVW to help us go ahead and break people out into groups. And again, please, you're going to be sharing with each other some of the resiliency strategies you're using to respond to and care for your own response to secondary traumatic stress. All right, so you should now be getting the invitations to go into your rooms, and please go ahead and join those rooms. We'll give you all about 5 minutes to talk through this. Thank you. Okay, so we should now have everyone back. Can I just get a confirmation real quick from OVW that people are back from breakout groups?
We're having most of them come back. I see the numbers just going exponentially. So we're at 126. They're rejoining.
Okay, wonderful. Well, thank you all for taking the time to meet with some of the other participants. Please, would you, if you heard a particularly, great approach or something that you hadn't thought about before, something that really resonated with you as a good resiliency technique or tactic, would you go ahead and just type it into the chat so that we can share that outside of your smaller groups with the rest of the room? And while you are typing in those examples, I'm going to just take a couple minutes to walk us through a couple of self-care techniques that you can employ, on the spot if you are noticing that kind of feeling. Mari Carmen explained that scenario where she was driving home, she saw the tow truck and she could feel kind of like in her body and her bones, the agitation and the feeling of that coming up. So here are some of the techniques, resiliency techniques, that you can go through and walk through in the moment. And someone posted a question in the chat about, if I'm seeing some of this in my coworkers or colleagues, what can I do to support them? And these tools are also, they could be incredibly helpful for you to kind of walk through with your colleagues. If you're seeing them being kind of agitated or feeling uncomfortable or having one of those responses, it may be a good moment to employ this, because a lot of these techniques kind of center on co-regulation of our emotions. So deep breathing, right? Just taking a collective deep breath as a group can be incredibly helpful in lessening kind of some of those impacts and some of the stress that we're feeling. Asking everyone at the beginning or the outset of a meeting to do a soft gaze and to put their feet on the floor, to relax their shoulders, to rub a soft stone, to mold Play-Doh, to moisturize your hands, and just focus on that sensation can be good resets. There's also something that's called the butterfly hug, and it looks like this. And it basically means you just tap alternating sides. And I promise you, the next time you feel really stressed out, if you take a minute and just sit tapping like this, there is something physiological about the bilateral stimulation that helps reset and kind of bring your emotions down and to a calmer level that can be really helpful. Similarly, you can use tapping on kind of this place on your hand to help kind of bring you down. And so this is something that I've used before in client meetings where I'm sitting across a desk from a client and I don't feel like I can just sit there and start the butterfly hug in the middle of what they're telling me, but I know I need to do some regulation of my own emotions. And so I will, under the desk, just kind of gently, calmly start tapping myself so that I can feel the regulation come back down a little bit there. There's also a technique that we call the 5-4-3-2-1 sensory exercise. And what it means is, and this is where you could do it with a colleague, right? You could say, okay, acknowledge 5 things that you're seeing around you. And likewise, you could do this with clients. Tell me 4 things that you can touch around you. What are 3 things that you can hear? 2 things that you can smell, and 1 thing you can taste. And it does that similar function of kind of grounding people and bringing them down.
So Morgan, I know we're running out of time, but I want to talk about, because sometimes we talk about self-care as if it's only something that the individuals can do, but what can organizations do, and what is the responsibility to self-care that organizations should have? And can you talk a little bit about that, like some of the things that we're doing?
Yeah, absolutely. I think first of all, self-care should not be self alone, right? We know that like trauma healing happens in community and collectively. And so there needs to be an organizational support to this. We're happy to provide TA on this and other ideas, but let me just give you kind of like a laundry list of things that we're doing organizationally that help kind of build out that self-care. We have billing codes for self-care. So advocates, after a tricky meeting with a client or conversation, can take a walk around the block. We start our meetings 10 minutes after, or 10 minutes giving a break so that people can like decompress between meetings. We have self-managed PTO for staff so that nobody has to ask to take a mental health day and justify why they'd need to do a mental health day. We've got sabbaticals so that people can take time away from the office, decompress, de-stress, get away. And then we do modeling. As leaders, I put on my calendar my therapy sessions so that everybody that I supervise and manage sees that I'm in regular therapy, and that's expected as part of the job and something that's normalized and accessible. And we also have employed outside resiliency consultants, therapist consultants that have come in and worked with our teams and staff on different resiliency techniques.
Thank you for sharing that. And I think one of the really important things that we're excited to share is some of the techniques that we're doing organization-wide. And, you know, as we get started on our TA work, we will be making that offering available. So if you want to consult or check in with us about, you know, some things that you could do to start, you know, doing or creating something that will promote self-care for staff and for the well-being of those that work with you, please do reach out. And I think with that, we want to close to make sure that we finish on time. I think we're right at 4 Central Time, and depending on where you're joining us. So thank you so much for everything that you do. And again, congratulations on being an LAV recipient and for all that you do.
Thank you so much, Mary Carmen and Morgan. It was great to hear you speak. Folks, before you hop off, please remember that you do have additional sessions through December and January. So please keep an eye on that email that we sent a little while ago with a full list of the sessions. You're not quite done yet, you're close. And then note that if you do have to miss a session for whatever reason, you should email your program specialist, and then also keep an eye out for an email from us with a certification form and some instructions. You'll eventually have to upload that form into Just Grants to certify that you did attend all of the required sessions, as did all of the required staff at your organization. And then just a final reminder that if you have any questions whatsoever through the life of your grant, do not hesitate to reach out to your program specialist. We're here for you. We want to make sure that you're succeeding. So we are always happy to answer questions. And with that, just a final thank you so much for being here. We really enjoyed getting to see you all virtually, albeit. And one more hearty congratulations on your LAV award. We are so excited to work with you over the next few years. Have a good evening, everybody.